4 relating to surface water permitting programs. When we broke yesterday, Mr. Parkhomenko was approximately halfway through his questioning of the department panel. Mr. Parkhomenko, I understand you are going to begin this morning with questions to Ms. Lemon.
Yes, that is correct. Should I begin now?
Yes, please, go ahead.
All right, well, and I apologize if my voice starts cracking. I seem to be coming down with something. But Madam Hearing Officer, Mr. Chair, members of the Commission, members of the witness panel, thank you very much for being here this morning and entertaining my questions. I promise I won't take too long. But my name is Konstantin Parkhomenko, and I am here representing National Technology and Engineering Solutions of Sandia, LLC, which is a contractor that runs the Sandia National Laboratories for the Department of Energy and the National Nuclear Security Association. Oh, administration, I'm sorry. And my questions this morning are to Ms. Lemon. Just a few things. Ms. Lemon, you are the department's principal witness on what waters this program reaches and on how its terms are defined, correct?
I'm the department's witness with several other witnesses for the program.
Mm-hmm. And so let's briefly talk about how the permits here under section 20.6.2 are triggered. So the permit requirement that is proposed under section 20.6.2.2302, providing that no person, it provides that no person shall cause or allow a surface water discharge without a permit. Is that correct?
That's correct.
And of course, surface water discharge is also a term of art. I believe it is defined in section 20.6.2.7, right?
I believe so. I'm looking right now. Yes, it is in there. It is also in the Water Quality Act.
Right. And so a surface water discharge under the proposal includes the discharge of dredged to fill material to a surface water of the state, right?
Yes.
So seems like everything here turns on that critical phrase, just what is a surface water of the state, is that right?
We have a definition for surface water of the state.
Right, so it's not defined separately in 20.6.2, but instead that section points to the existing definition in 20.6.4.7 S5. Is that right?
Correct. Those are the surface water quality standards in 20.6.4 NMAC.
But those surface water quality standards in 20.6.4, set surface water quality standards, but they did not create a permit requirement carrying civil and criminal penalties, as this rule does. Is that right?
The surface water quality standards set the goals for every surface water of the state. So I would argue that the permits are designed to protect those surface water quality standards.
Mm-hmm. So I guess my point is, would you agree with me that it's fairly important for a contractor such as ours, or even an average citizen seeking to comply with this rule, to understand whether their activity is going to actually be disturbing a surface water of the state?
Is there a question? I'm sorry.
That's the question. That's my question. Would you agree that it's important for them to know if something is surface water of the state or not?
If a, can you repeat the question?
Sure. Would you agree with me that it's important for a party seeking to comply with the proposed rules, either a party such as ours, a federal contractor, or even an average citizen? Would you agree with me that it's important for such a party to know whether activities they will be engaging in will be disturbing a surface water of the state or not?
If they are discharging a contaminant or pollutant or dredge and fill material to a surface water, yes.
And some of your fellow citizens, some of your fellow witnesses earlier testified that dredge and fill material could actually be clean soil, free from contaminants. Is that right?
Sediment is considered a contaminant, so it depends, yes. Sediment is a contaminant that's regulated under the Clean Water Act and Water Quality Act. We have water quality standards for sediment and sediment related contaminants. We look at turbidity, we look at sediment in the stream bed. So sediment is considered a contaminant.
Yeah, so that was my point, is that any average citizen might look at clean soil and say, well, that's free from contaminants, but that still qualifies as a contaminant under the framework of the proposal, if it happens to be, discharged as dredge and fill, right?
Yes, dredge and fill.
So let's talk about the meat of the issue and our main concern, which is how you actually determine what is and is not a water of the state when it comes to ephemeral streams. So my first question there is, you understand that an ephemeral channel in New Mexico could be dry a great majority of the time, right?
That's the definition of ephemeral, yes.
So it only has water in it in response to precipitation, correct?
Yes.
And so I think the rules also use the term watercourse, which is identified by the presence of a bed and banks. Is that right?
The surface water permitting rules do not use water course. 20.6.2 NMAC does have water course, but the regulations being proposed in section 2300 through 2354 do not have water course in them.
So would you agree that the bed and banks test is a recognized way to identify a channel in the field?
For implementation, yes. There's other factors as well that you look at when you're looking at a stream.
All right. Can you elaborate?
When you are implementing the regulations and looking to collect water quality data and evaluate the stream condition. Again, my bureau collects biological, chemical, and physical data associated with surface waters. So that physical data includes looking at the geomorphology, how wide the stream is, how deep the stream is, looking at the floodplain width and various different measurements to evaluate the condition of the stream and whether or not it is impaired. So we
Right.
evaluate based on multiple factors when we implement the rules.
And when we say stream, we do include ephemeral waters in that, right?
Correct.
That are dry most of the year.
Correct.
So
Yes, we have water quality standards for ephemeral streams, and we recognize that ephemeral streams are surface waters of the state.
right. So the permit trigger itself in the rule does not apply the bed and banks test. It seems to turn on whether a feature is a surface water of the state or not. Is that right?
That's correct.
So if something is a surface water of the state, then it will need permit. But if it's rather an erosion feature or something else, then it will not need a permit. Is that right?
If you plan to discharge contaminants or dredge and fill material, yes.
But the department has not actually published a map identifying where every surface water of the state is. Is that right?
I don't believe EPA and the Corps have done so either. So we are working on a map, which will be a tool for looking at surface waters in the state of New Mexico. But even at the federal level, that is not something that has been done either. But our map, we are working on a map to help implement this rule and help people look at whether or not they may need a permit. But we always recommend that they contact the department or the Army Corps of Engineers or possibly EPA if they have questions.
Right. And so sitting here today, and let me be clear, do you oversee the program that will actually administer this permit trigger?
Yes.
So sitting here today, can we point the commission to a provision of the rule that will give a landowner a concrete test or a map to determine whether channels on their land might be covered?
Again, that's in implementation and it's not set in rules. So those features, those guidance documents, mapping tools, all the things we use to implement the rule will be available when the rule is effective.
And that implementation is going to be under the department's complete discretion. Is that correct understanding?
Not entirely. It is part of our water quality management plan and continuing planning process, which comes before the commission.
Right. So it's part of the process, but ultimately the department determines whether something is or is not a water of the state. Is that right?
As the regulatory authority, yes, but there are opportunities to appeal that decision to the commission and to the Court of Appeals.
Right. So the average landowner who wants to comply, let's say we have, not even us, I mean, but a rancher, right? And they've got some channels on their property, or what looks like some channels. Maybe you have two ranchers, and they might look at the same channel and come to opposing conclusions about whether it's a surface water of the state or not. What would you tell those people to do? Call the department and ask them?
If they want confirmation, that would be one route. If they want to proceed and take the risk, that's another route. It's a hypothetical, so I don't know.
Yeah, but the rule itself provides them with no test to be definitively sure if something is a ephemeral stream or an erosion feature.
I don't know. A definitive test, we have a list of surface waters of the state. Those are also defined in the rules. So looking at the combination, if you have some background in hydrology or natural resources, you should be able to determine if your stream or water feature meets that definition of surface waters of the state.
Well, ma'am, respectfully, Sandia National Laboratories has some of the best world-class, I would say, people working for them, including world-class hydrologists. And even our people have problems determining, based on the text of the proposed rule, whether certain features on our land or the Department of Energy's land, rather, that we administer, are ephemeral waters or erosion features. So do
Mr.
you think how an
Parkman,
average person might have a real difficulty there, being not being
Mr.
sophisticated?
So I'm sorry to interrupt you. She's already said that when the rule becomes effective, there will be a number of guidance documents so that the determination as to whether something is an ephemeral water will not be made only on the basis of the text in the rule. And please avoid making statements. But do you have other questions of the panel?
Yes, I do. And we will get to the guidance documents shortly. In particular, I'm very curious about those. Ms. Lemon, how will the department apply the tributary rule with regard to tributaries of an ephemeral stream that is a surface water? What I mean is, where would you draw the line? Would only the first order tributaries be regulated, or second order? Are you going to draw a line anywhere at all?
Can you point me to the tributary rule you're referring to?
It's a framework for determining whether something is a disconnected water or part of a larger stream model.
If the tributary is an ephemeral stream, it will be regulated. If it's an erosional feature, it will not.
Mm-hmm.
So it would be up to the first order. We regulate right now and have water quality standards for headwater streams. Those are first order.
Will the department give any consideration to the distance of the ephemeral stream from a perennial water or a navigable water in deciding whether to regulate that stream as a surface water of the state?
That is difficult to say. The criteria will be different because it's an ephemeral stream versus a perennial stream, but we still have water quality protections for ephemeral streams that we intend to regulate.
Right.
Now,
So
the requirements may be less stringent based on where you're at and the impacts, whether it's a minimal impact or a cumulative impact. So those things will be considered when we issue general permits and individual permits.
right. So was that a yes or a no? I wasn't quite sure. Are you planning to consider distance from perennial waters at all?
Not as a flat consideration.
All right. So let's say that there's a large storm and it disturbs an area and creates a new channel, could that new channel created after a storm be considered a new ephemeral water, or would you consider it an erosional feature under the rules framework?
I don't know.
So if the rule doesn't contain criteria to limit the reach of the rule to ephemeral streams, then will the commission be leaving, or do you want the commission to leave this decisional discretion to the sole discretion of the department?
Again, it's not the sole discretion of the department. If we require a permit for some sort of discharge, there is ability to appeal to the commission and to the Court of Appeals if somebody disagrees with our determination.
But the determination itself is up to the discretion of the department.
As the regulatory agency responsible for this, yes.
Let's, and I was thinking about this last night, but let's say there's a paved parking lot that's built, and it's a man-made parking lot, obviously. And as part of good management practices, you'd build a concrete channel to channel the water out so that you don't have standing water in the parking lot. And so the water flows down and creates a channel in the ground. Would that channel then be a surface water of the state that would require a permit?
I don't know. I would assume not. But without that being something that we're evaluating, I have no idea.
Switching gears just briefly, I think the definition that was incorporated under 20.6.4.7 S5, I believe it contains waters of the United States as part of the definition of surface waters of the state. Is the department now trying to exclude waters of the United States from the definition of surface waters of the state?
In the Exhibit 79, we did make a change to the reference in 20.6.4 to exclude waters of the US for the state program, because we are only under the state program regulating surface waters that are not federally protected. So yes, we did make that change in Exhibit 79.
So, and that was the reason to clarify that it was only a pure state program and not a federal program?
That's correct.
Under the proposed rule, the definition of wetland will defer to the definition in part 20.6.4. Is that correct?
Yes.
Isn't the department proposing to change that definition in the upcoming triennial review?
We do have a triennial review coming up, and we are looking at adding some wetlands information into the triennial review to align with the permitting program.
Mm-hmm. And isn't it your testimony that any changes made to the definition as part of the triennial review will be automatically applied to change the surface water permit rules?
Yes, which is why we are aligning them, because we are aligning, the permitting program must meet the water quality standards, which are in 20.6.4. So that's where we are aligning the two sets of regulations, the water quality standards with the permitting program. And that triennial review will go through the same public review commission hearing as we're going through right now.
Mm-hmm. Under the switching gears a little bit, under the NMPDES permit program and the state program under 20.6.2, both of those, does the department intend to propose general permits that mirror all of the stormwater general permits currently issued by the United States EPA?
We are looking at issuing general permits. We are using EPA's as our template, but it may not mirror exactly because EPA's permits are national permits, not New Mexico specific permits.
Mm-hmm.
But we're using those federal permits as templates.
And that's good to know. Will the department be, I guess, narrowing or excluding any part of the? Well, let me just ask you in general. How do you plan the state general permits to differ from the federal ones?
They will have New Mexico specific requirements in them.
Mm-hmm.
I'm not sure what you, I mean, we have not drafted them, but once we draft and issue them, they will go through a public review and participation process.
Any word on the general timeline for when proposed general permits will be available?
We have to get through the rulemaking first before we know what the requirements for a general permit are.
Okay. And so absent a general permit, if assuming the rule passes, the applicant would have to apply for a permit for a specific activity. Is that correct?
Are you talking about an individual permit
Mm-hmm.
or?
That's correct.
No, they, just a second. We did put some language to help with the interim period between the time the rule is effective and the time that the department will be able to issue general permits.
Mm-hmm.
And I'm trying to determine which exhibit it is in. It's in 79, exhibit 79. We added language that allows people to receive temporary authorizations for either point source like stormwater discharges or dredge and fill discharges to surface water, and that those temporary authorizations will be issued for 3 years, so 2027 through 2029, and they will be effective until we issue a general permit that covers that discharge. So once we issue that general permit, the permittee would transfer and request coverage under the general permit.
And that's the exhibit 79. That's the amended petition, right?
Yes. Not the amended petition. It's exhibit 79.
Oh, right. That's what we are. Okay. Switching gears briefly, I'd like to ask about the emergency permit provision in 20.6.2. Who would determine whether property damage would be severe enough to grant an emergency permit for circumstances where property would be damaged?
This is similar to what happens with the U.S. Army Corps of Engineers. It's usually during a wildfire or a flooding event or flooding after wildfire event. So it's it's really up to the discharger to say, hey, we're having an emergency. Here are the reasons. And, we provide that emergency authorization, and then they come back after the emergency is over and we rectify what we need to rectify.
Right. And so who actually makes that determination about what's severe enough?
I think it's the discharger who's saying we have an emergency and we need to do these emergency actions. And we
Right.
confirm it.
But you confirm it.
Well, we issue the temporary emergency authorization, yes.
So that's also discretionary. If somebody in the department disagrees, they can deny that, right?
Possibly. If it's an emergency, it's an emergency. We work on emergencies at the department level. We respond to wildfires, we respond to floods, so we understand those situations that need attention and can't go through the normal permitting process.
But are there clear well, let me just move on. I think we understand the point I was making. Now, under the proposed rules, I understand the department may request additional information from a permit applicant during the department's review of the application. Do the proposed rules limit information requests in scope to only relevant information?
I'm sorry, I missed the last part of that question.
I'll go slowly. Do the proposed rules limit information requests only to relevant information?
Are you asking if the word relevant is in the rule?
That is not exactly what I'm getting at. What I'm getting at is that the department doesn't appear to be limited in what they can ask or how many times in the course of requesting that additional information. Is my understanding right, or would you like to provide some limiting language for us?
It would be related to the permit application, trying to clarify things or missing information. So I'm not sure, like asking non-relevant information or data would be applicable. We're reviewing the application and we're requesting information and data related to that application to draft the permit.
Well, but is that your assumption, or is that a limitation built into the rule?
That is how it works.
So that's not in the rule.
I believe it is in the rule because it's under the applications and individual surface water discharge permit section.
So just because it's in that section, your testimony is the department is limited to only asking about information that relevant to the application?
Relevant to the surface water discharge, yes.
I mean, that would be great if that was the case. I didn't see that in the rule language, but I'll move on. If the department asks for additional information, would that mechanically restart the time limits for the department's review of the application?
I believe Mr. Fuad will be covering the processes, but to answer that question, the time pauses. It doesn't restart.
Mm-hmm.
It pauses and we provide a timeline to respond.
Right. So you can't have this endless chain where the department feels like they need more time, so they just keep asking for more and more information, and that restarts the time frame. That doesn't happen.
That typically does not happen, no.
Right.
And in my experience with the federal programs.
In your testimony, you emphasize that the department may regulate surface waters discharges more stringently than under federal law. Is that correct?
In my testimony, yes.
Does that position apply to both pieces of the rules, both 20.6.5 and also 20.6.2 rules, or only one of them?
It applies to both. In 20.6.5, we have to meet the minimum federal requirement, but the state can implement the program more stringently. Our water quality standards, some of them align with federal regulations. Some of them are more stringent than federal regulations, which is why we have 401 certifications of the federal permits right now.
Mm-hmm. And are there any limits in either of those rules on the level of regulation that the department can impose that is beyond the level of regulation specified under federal law?
Can you reframe that? I'm not sure I can answer. That's broad, and I don't know how to answer that.
Well, I guess what I'm getting at is how far can you go? If the department's position is we can be more stringent than the federal law, then how do we know how much more stringent and you know how far can you go, basically, is the question.
We have to regulate the regulations that are adopted by the commission. So whatever the commission decides is the level of protections and regulations that the department must administer.
Your testimony criticizes federal law for reducing the jurisdiction over waters of the United States. Is that right?
I don't think I criticized it. It was a statement of fact.
Do you have any other specific concerns with federal permit regulation that would warrant more stringent regulation by the state?
We are here to adopt regulations. That's what we're talking about and what this hearing is about. So I don't quite understand that question.
Well, I mean, you said that you wanted to be more stringent than federal law, and I'm just trying to clarify, like, what are the concerns driving that?
The rules that we proposed are what we are proposing that the commission adopt. So you have it in front of you.
Right, but I was asking for the rationale behind. I'll move on. I don't want to waste time. Madam Hearing Officer, may I ask how much time is remaining?
You have 13 minutes left.
Thank you. That should be plenty of time. Ms. Lemon, your testimony identifies the need for written guidance to be developed by the department in several areas, including, I believe, the extent of jurisdiction of surface waters. I think there was some testimony regarding guidance on erosional features and things like that. My question is, do the proposed rules require that such written guidance be published, and that the department must consider public comments?
No, typically, in a regulatory program, you have the statute that defines the laws, then you have the regulation that implements the statute, and then you have guidance to help explain the rules and how the regulatory agency is administering those rules. So there's 3 steps in the process, and those guidance documents help to explain how the department or any regulatory agency looks at the rules and is applying the rules. That process, the guidance documents are typically, it depends on the regulatory agency. But again, like we have some guidance documents that are approved by the commission. We have some guidance documents that go through public comment, but are not approved by the commission, or for some products that eventually go to the commission. So there's definitely interplay and public comment and participation and commission comment and participation in those procedures.
So to be clear, the proposed rules do not require that such written guidance must be published and for the department to consider public comments, right?
I don't think any rules have guidance documents in them because they're guidance documents.
Right. And this guidance document would help people determine whether, among other things, whether an erosional feature is an erosional feature or an ephemeral water that would require a permit. Is that right?
That could be one of the guidance documents.
But the public would have no input into that.
I don't think so. I think that the public would have the ability to, again, appeal any decision that the department has made, appeal our decision based on a guidance document, appeal a decision on a permit requirement. We have that process set up for public participation and comment.
So is there any reason why the department didn't include this guidance document as part of the rule language that's being proposed so that the public could comment on them now?
Again, guidance documents are an implementation piece to implement the rules. They're typically used by the regulatory agency and are not in regulation. If the regulations need to change at a later date because you're finding that it's not working or something is wrong, then the regulations go through revising and another hearing.
Right. So if you call something a guidance document, that's an implementation piece, is that required to be made available to the commission for its consideration?
If it's part of our water quality management plan and continuing planning process and other processes, yes.
So the commission will approve it what the department puts out here, is what you're saying.
They may. It depends on the type of guidance document that we're talking about and whether it falls under items that we already bring forth to the commission. In other words, there's different types of guidance documents.
All right. So speaking about the guidance document, specifically on erosional features, what would be the process for implementing that?
For implementing the guidance document, we would use our guidance document to draft a permit.
Yeah, which the public would then be bound by.
No, again, you can appeal that decision.
Okay. Well, I think I made the point. I'll just move on. When the commission adopts these regulations, it must weigh certain statutory factors, including technical practicability and economic reasonableness of the regulation, right?
Yes, I believe so.
There was testimony presented about the department's program cost estimate. Is that right?
Yes.
But your testimony does not quantify the compliance cost to regulated parties. Is that right?
Not entirely. Compliance costs right now, if they fall under the NIPD's federal program, they're already paying those compliance costs. So it's really the additional state permitting program that will have those new compliance costs. And we're anticipating that most of those permittees will be general permits and limited individual permits.
So has the department looked at, well, let me back up real quick. Were you present when I asked Mr. Connolly about how compliance costs are more than just permit fees?
Yes, I'm sitting on the panel.
So you do recall, I'm sorry, I misspoke. I meant to say, do you recall? So do you recall me asking about things like the costs of functional assessment, costs of compensatory mitigation, or cost of a study to delineate whether a feature is jurisdictional or not?
I remember you asking questions of Mr. Connolly. Yes.
Mm-hmm. Has your testimony looked at any of these costs for the permittee?
My testimony does not cover that.
Has any witness looked at those, to your knowledge?
I don't think we talked about an economic analysis in that sense. We're required to look at the reasonable economics of the program and the cost of the program and the cost of, that's going to be up to the person who is proposing to discharge contaminants into surface waters. And if that's something that they want or need to do, they're going to have to evaluate that.
Right. Real quick, I believe under the proposed 20.6.2 point 2303, under the enumerated exemptions, there is no de minimis exception for permit. Is that right?
In 2303,
2303?
there is no de minimis. Those exemptions are exactly from the Clean Water Act.
Right. So there's no size, volume, or acreage below which a discharge escapes the permit requirement, correct?
That's correct. Same as the federal requirements.
All right. And the effective date, am I correct in understanding that the state program regulations would take effect 30 days after filing?
I believe it's 30 days after publication in the New Mexico Register.
Right, right. So 30 days after that. So is there any kind of, there's no grandfathering clause or anything like that being contemplated, is that right?
There's no grandfathering, but again, in Exhibit 79, we added some language that allows for that transition. Not only those temporary authorizations, but also when to submit permits. I think we provided 180 days if the discharge is happening at the time that the permits become effective. I'm trying to look at the rule right now to get it. Just a second.
Oh, that's all right. We can move on.
Mr. Parkhomenko, your time has come to an end. She
Oh.
really has been diligently looking.
All right,
during
all right.
the-
Well, that's
time
that's fine. I appreciate everybody's time. Thank you very much.
Thank you. Mr. Wexler, how will the agricultural districts be conducting their examination?
To answer your question, I will be asking questions first. I expect that Mr. Domenici and possibly Ms. Stevenson may have some additional questions.
Thank you so much.
May I? Good morning to the panel. My name is Jeff Wexler. I represent the Middle Rio Grande Conservancy District, which I'll call the MRGCD. The testimony of Mr. Armstrong was reassuring for us, but we have a number of questions related to our specific concerns and specific proposals that we've put forward. I think most of my questions are for you, Ms. Lemon, but I invite any of the panel to please chime in. Ms. Lemon, are you familiar with MRGCD?
I am.
I'll represent that MRGCD is a public entity organized under New Mexico law to provide irrigation, flood control, and drainage services in the Middle Rio Grande Valley. I assume that you do not know how many miles of canals, drains, ditches, and levees in MRGCD, is that right?
Not off the top of my head.
I
No.
wouldn't expect. So you also don't know how many culvert crossings are within the MRGCD right of way?
No.
Will you agree with me that MRGCD plays an important role in supporting agriculture in the Middle Rio Grande Valley
Absolutely.
and in managing flood control and drainage for communities in the Middle Valley?
Yes.
I want to start with a regulatory baseline for the last 50 years. And I asked some of these questions to Mr. Armstrong. I want to understand your perspective. As Mr. Armstrong confirmed, MRGCD's irrigation canals and laterals are not currently jurisdictional waters of the United States under the Federal Clean Water Act. Is that also your understanding?
I have not seen a jurisdictional determination, so I can't fully confirm, but I'll take your word for it.
Have you reviewed Mr. Kasuga's direct testimony?
I've reviewed it, yes.
There was an MRGCD Exhibit 3 as a jurisdictional determination just from the last year or so. Do you recall that?
Not off the top of my head, but I will agree with you if it's in there.
Are you aware that EPA has never required a NIPD's permit for MRGCD's drains?
Yes, I would agree with that. I have not seen a NIPD's permit for MRGCD.
Even though those drains may carry some non-agricultural flows.
That's correct.
And MRGCD has also never been required to obtain a federal Section 404 dredge and fill permit for routine maintenance of its canals, drains, or levees. Is that your understanding?
I don't believe I've seen a 404 dredge and fill permit for MRGCD.
Of any kind? Does that include emergency reconstruction of levees or drainage facilities?
Yes, I have not seen it for specific. I know there are some letters of permission and things like that, but I don't know if that applies to MRGCD.
On page 19 of your direct testimony, you testified that the exemptions in the proposed rules are consistent with permitting exemptions in the Clean Water Act sections 402 and 404. You go on to say that the NIPD's Act and the Water Quality Act, is that right?
Yes.
And on page 20, you testified that the department was intentional in the way that it addressed those exemptions. Do you recall that?
Yes.
You also testified that the regulations use the same surface water permitting exemptions that have been used for the last 50 years under the Federal Clean Water Act. Is that your testimony?
Yes.
And that includes the agricultural exemptions?
That's correct.
We heard from Mr. Armstrong that the department's intent is that irrigation districts like MRGCD would be in the same position under the proposed rules as they have been under the Federal Clean Water Act for the last 50 years. Do you agree?
Agree.
And so on this point, I think MRGCD agrees. I think my remaining questions and the concerns of the district are intended to explore the specific language of the rules in order to ensure that intent is accomplished. First, one last sort of background thing, and that is in thinking about the basis for the proposed rules, your testimony doesn't identify any specific water quality problem caused by MRGCD. Is that right?
No.
And I just want to make sure these are all true. So, for example, the department hasn't received any complaint or monitoring data, including that or indicating that MRGCD's drains are causing water quality problems.
I would have to probably defer that question to Susan Lucas-Kamat in the Fils Fouad, because I may not see everything that's coming through the department, but overall, I haven't heard of anything.
Fair enough. There's nothing in your testimony.
Right.
And there's you're not aware of any evidence, or there wasn't any in your testimony that there's a water quality problem resulting from MRGCD's routine dredging or levee maintenance operations?
I have not, my testimony did not cover that.
And the department, to your knowledge, has not identified any instance in which MRGCD's emergency levee reconstruction caused a water quality problem?
Not, again, my testimony did not cover that.
Fair enough. Let's turn to the definition of surface waters of the state, which is in your testimony, right?
Mm.
Now, the definition is, well, you testified that the commission adopted the definition in 20.6.4 NMAC during the 2003 triennial review. Is that right?
That's correct.
And that was, at least at the time, was for purposes of water quality standards. Is that right?
To protect surface waters, yes.
And there's been a little bit about discussion about this with you, and I just want to clarify some of those questions. When it was adopted in that 2003 triennial review, there was no discharge permitting program, right?
It was the federal programs.
Right. So there was no state program.
There was a federal program where we issued 401 certifications.
Fair. There wasn't any. The state did not have authorization, for example, over 404 permitting.
No,
So unlike that 2003 context, under these proposed rules, that same definition of surface waters of the state is being used as the jurisdictional trigger for a new permitting program. Is that right?
it is being used because those are the surface waters that we have been protecting for over 20 years.
And so it serves as the jurisdictional trigger, right?
Similar to the federal program, when we certify federal permits, yes, we're certifying those water quality standards, but the state program, because the federal jurisdiction has shrunk since 2003, we are using those surface waters as what we want to protect in this permitting program.
That's fair. And I appreciate that extra explanation. I want to make sure that the answer to my question was yes, that it is serving as the jurisdictional trigger for these rules. Is that right?
Yeah, the surface waters of the state.
Thank you. Under the definition in that 20.6.4.7 S5, this is I think it's Department Exhibit 27 if you want to look at it. Surface waters of the state includes, among other things, all tributaries of listed water bodies. Is that right?
Means all tributaries of such waters.
It also includes any man-made bodies of water that, and I'm skipping a few words, resulted in the impoundment of surface waters of the state. Is that right?
Yes.
So I want to ask a little bit about each of those terms, the tributaries and the impoundments. So the term tributary is not defined anywhere in the proposed rules, meaning it's not found in the proposed changes to 20.6.2, and it's not found in the proposed 20.6.5. Is that right?
It's in 20.6.4.
Thank you, but it's not in the proposed rules, right?
No, but it's in 20.6.4.
Yes, so I'm getting to that now. So then the term within the 20.6.4, and I think it's .7 T3, right?
Yes.
And so tributary is defined to mean any perennial, intermittent, or ephemeral water body that flows into a larger water body, including a tributary of a tributary. You see that?
I do.
As we just heard, that definition includes ephemeral water bodies, right?
That's what you read, yes.
Yeah. As you're aware, I expect some of the MRGCC's irrigation canals carry water that ultimately flows back into the Rio Grande system.
Yes.
And in fact, those flows occur only during the irrigation season. Is that your understanding?
Yes.
And so in that sense, are they considered to be ephemeral?
They're probably intermittent because they're seasonal.
Are they considered to be tributaries?
They're part of the return flows.
So then they'd be subject to the agriculture exemption for return flows.
Yes.
Got it. Are you familiar with the Army Corps of Engineers interpretation in its Section 404 jurisdictional program? Let me just stop there. Are you familiar with the interpretations of the Army Corps of Engineers? Well, in this one, they've historically distinguished between ditches in excavated in upland areas, which are typically not jurisdictional, and ditches that are excavated in natural channels, which typically or may be jurisdictional. Is that your understanding?
Can I have
Yes,
Ms.
please.
Dr. Devet?
Are you, you're stating that you're differentiating between waters that are created in uplands or dry land or actually are created in waters of the US?
Yes, that's correct. And
Yes.
and is it your understanding typically that the Corps has said those that are in the upland areas are typically non-jurisdictional?
Those waters that have been created even historically in dry land are generally non-jurisdictional, yes.
The proposed rule doesn't import that distinction, at least not expressly. Is that right?
I would actually disagree. When I read this, I actually got that from this. And I can't specifically point to where, but I do remember in reading it that I thought, oh, that's really good that they have incorporated some of that as well.
Okay, so is your understanding that somewhere, and you can't point to the specific language, but that essentially that the proposed rules include that concept? Is that a yes?
I'm sorry. Yes, I'm nodding my head. You can't hear the rocks. Yes, that actually is my opinion, my assumption. Yes.
Thank you. And I think this question may go back to Ms. Lemon only because she's with the department, but is that the department's understanding as well?
I would consider anything in the uplands to be a man-made structure that is not originally in a surface water of the state, right?
Turning to the definition of impoundment, am I correct that there is no definition of the term impoundment in the proposed rules?
I don't believe that.
From an engineering perspective, and this comes from Mr. Kasuga's testimony, impoundment typically means a structure that captures and stores water like a reservoir or pond. Do you agree with that?
I would.
And for purposes of these rules, is that how the department is intending on interpreting impoundment?
I would, yes.
Is there any reason or is the department opposed to the commission defining impoundment within these rules?
If there is a valid definition, none was offered. So right now, it does not have a definition in there.
Fair to say then it depends on what that proposed definition said.
Yes.
How about this? Which is your answer the same if MRGCD were to propose a definition of tributary?
Again, it depends on what that definition says and what the reasoning and how it was developed.
I want to turn to the question of composed entirely. And I have a number of questions there just to sort of set the stage. As originally filed, I think this was maybe Department Exhibit 28, and we'll get to the changes. As originally filed, the proposed rule at 20.6.2.2303 A1, these are the exemptions, exempts from the state permitting program return flows composed entirely from irrigated agriculture or agricultural stormwater runoff. Is that right?
Yes.
And so similarly, again, setting the stage here, the original language of the proposed rule, this time at 20.6.5, which is, I think, the original one was NMED Exhibit 29. And I'm looking at subsection 102A, exempts a discharge composed entirely of return flows from irrigated agriculture and agricultural stormwater runoff. Is that right?
That's correct.
And so each of those definitions includes that phrase composed entirely, right?
Yes, and that is based on both the Water Quality Act amendments and NMIPD's Act from Senate Bill 21.
Understood. In fact, that the same language, that composed entirely language, it actually appears in the Federal Clean Water Act, right?
Correct.
And for the record, that's a 33 USC section 1342 L1, I think is what it is, but I won't test your memory. And there it's in the it's in the context of the exemption from the NIPD's permit requirements, right?
Yes.
But the federal implementing regulations, even though the Clean Water Act includes that composed entirely, the federal implementing regulations do not include the language composed entirely, right?
I believe that's correct.
In your rebuttal testimony, and you do it at 2 different pages, and it's where you're talking about composed entirely at pages 13 and 25. You cite to the Ninth Circuit's decision in a case called Pacific Coast Federation of Fishermen's Associations versus Nichols. I'm just going to call Nichols. I assume you've read that case.
I've read parts of it, yes.
I'm not going to ask you legal questions, but I'm going to ask you some interpretations and try and understand the department's position on the reasoning. In Nichols, the Ninth Circuit addressed whether the agricultural return flow exemption was forfeited when non-agricultural flows commingled with agricultural return flows in an irrigation drainage system. Is that your recollection?
Yes.
And is it your also your recollection that the Ninth Circuit held that the agricultural exemption was not forfeited by the commingling of those non-agricultural flows?
Yes.
Because you cite that case favorably, I take it you agree with that outcome?
Yes. Our intent is to administer how the federal agencies have been administering the program. So, yes.
Including this, your understanding of that Nichols case?
Yes.
And I just have a few other questions about sort of the reasoning there. In that case, the court held that composed entirely does not mean that every molecule of water has to originate from irrigated agriculture. Do you agree with that?
Yes.
And the Ninth Circuit also described the composed entirely language as ambiguous. And do you agree with that?
It's created some consternation. Yes.
In fact, the proposed rules don't have a definition of composed entirely. Is that right?
We do not.
Is the department opposed to a definition for composed entirely? Again, understanding you'd have to see the specific language.
Any definitions are welcome to help better clarify and implement the program. Again, it depends on what the definition says.
Fair. One last question about Nichols, and then I promise to move off any federal court cases. In the Nichols case, the Ninth Circuit warned that adopting a literal definition or standard of composed entirely meant that the exception is lost whenever non-agricultural flows is present in any amount, and that would render that exemption a dead letter. Do you agree with that reasoning?
Can you restate?
It was.
I think so, but
yeah, I think they basically were saying, like, look, if you strictly construe composed entirely to mean that whenever there's any non-agricultural flows present, that it means the exemption's not there. And the Ninth Circuit said, well, that would mean the exemption was meaningless without any purpose. And do you agree with that?
I agree that composed entirely, we have non-point source flows coming into the agricultural return flows. That doesn't mean it's coming from agricultural land. So yeah, I would agree that composed entirely is not specific.
Turning then to how this sort of plays out for MRGCD, the MRGCD's drainage system operates in a mixed agricultural, urban, suburban, and rural environment. Are you aware of that?
Yes.
There's 3 separate sources of water enter MRGCD's drains. There's the agricultural return flows. There are some permitted urban and suburban stormwater. And then there's groundwater seepage and incidental flows. So does that sound right to you?
Sounds about right.
There's actually 3 entities, I believe, and correct me if I'm wrong, Amafka, the city of Albuquerque, and Bernalillo County that have NIPD's permits for discharges into MRGCD drains. Are you aware of that?
Yes,
And those permitted stormwater flows enter and commingle with MRGCD's agricultural return flows, right?
yes, and they are permitted.
You mean the flows going into the
Going in,
MRGCD
yes,
drains?
yes.
But the MRGCD drains are not subject to the NIPD's requirement, right?
That's it for agricultural return flow. Yes,
Right. So in other words, MRGCD has historically been subject to the agricultural exemption, right?
yes,
And that wouldn't change under your proposed rule.
that's correct.
You do and so now I just want to get to the changes that you were proposing in the department's exhibit 79, and I think it's in both A and B. First, to set the stage, in your rebuttal testimony, you addressed the agricultural return flow exemptions for both 20.6.2 and 20.6.5. And I'll get you to turn to page 25 of your rebuttal testimony. And there you say, the department agrees with the joint agricultural district's proposal to delete the qualifier composed entirely from the exemptions listed in, and I won't repeat the language of the rule. And that was your rebuttal testimony, right?
That's correct.
And at the time you filed that, you hadn't identified any technical problems with the change in the language, right?
No,
So yesterday, or I'm sorry, it was yes, I believe it was yesterday. We heard that the department is suggesting to the commission to put back the language composed entirely. Is that right?
yes,
And that's reflected in 79A and 79B, right?
yes.
If I understood correctly, the reason the department is now suggesting that the composed entirely language be returned to the rule is that the department is trying to be responsive to the NRP motions. Is that right?
Yes.
Is there any particular motion, or do you recall? If you don't recall,
There were a
okay.
lot. So, no, I don't recall.
So I did go back and review the NRP motions, and I did not specifically see them arguing that the language composed entirely should be included in the exemption part of the rules. Do you agree?
Again, I would have to look through to find what we were responding to.
Fair enough. So you, as you sit here today, you're not able to identify that language in any of those motions. We haven't heard yet from the NRP witnesses. If I ask those NRP witnesses, and those NRP witnesses say they're not advocating for the words composed entirely to be included in the exemption language of the rules, will the department support removing that language again?
I'm not sure. Again, I would need to confer with my lawyers to make sure we're in alignment and can say that affirmatively.
Understood. We'll stay tuned on that as the hearing evolves. Will you agree with me that neither the Water Quality Act nor the NMAC Act define composed entirely?
I believe that's correct.
And I already asked you, you'd be willing to entertain language potentially for a definition of composed entirely that might address this whole issue.
If you can clarify it, or
Thank you. Couple other topics. The proposed rule, and this, I want to talk a little bit about the dredge and fill exemptions. The proposed rule this time at 20.6.2, 2303B2 provides a dredge and fill exemption for The quote is maintenance, including emergency reconstruction of recently damaged parts of currently serviceable structures such as dikes, dams, levees, riprap, breakwaters, causeways, and bridge adjustments or approaches and transportation structure. Is that right?
If you're reading from it, I'm scrolling to get there. So
I was trying to read from
sure.
it. I hope I read it correctly. In your direct testimony at page 21, you testified that this exemption applies consistent with Federal Clean Water Act, Section 404 regulations and implementation. Is that right?
Yes,
You testified that the emergency reconstruction has to occur within a reasonable time, period of time after damage. Is that right?
I believe so. Yes,
And you also testified that the exemption does not include any modification that changes the character, scope, or size of the original project design, right?
I believe so. Yes.
When the Rio Grande is running really high, unfortunately, we haven't had that problem recently, but when it does happen, and I hope it happens again in the future, and the levees are under stress, are you aware that MRGCD must sometimes respond to active levee sloughing, meaning that the levee is actively failing?
Yes.
And in that situation, MRGCD must respond immediately to prevent flooding of adjacent communities.
Yes.
And that response may require placing more riprap or fill material than was originally present in the levee. Is that right?
If it's failing and being removed and you're replacing it, yes.
It may also require reinforcing sections to meet current design standards, which sometimes are more stringent than the original design standard. Is that right?
Potentially, I don't know.
Will you agree that when a levee is actively sloughing during a flood event, MRGCD cannot pause to determine whether the work requires a permit?
I believe that's part of our emergency. Well, in your case, in the Middle Rio Grande, it's a water of the U.S. So you would be dealing with the Army Corps of Engineers if that's failing based on Rio Grande flows. Is that correct?
Well, so this goes back to that jurisdictional determination that the Army Corps does not consider the works of MRGCD to be a jurisdictional water of the United States. If assume with me for a second that that's true, are those waters flowing through the MRGCD facilities considered to be state waters?
Through the canals?
Yes.
That's that's a good question. I mean, again, the department's intent is to apply these standards and exemptions consistent with the federal programs. So that would be my response.
That's helpful. So does that mean if MRGCD was never required to obtain a federal Section 404 permit for this kind of emergency reconstruction work, that means that they also won't be required to obtain that permit under the proposed rules?
That again, if we follow the exemptions for the state rules, they're the same as the federal.
Is that a yes?
Our intent is to have the same exemptions, yes.
Different exemption, some of these similar kind of ideas. This one is the same number, 2303B3. This is the exemption for, the quote is, construction or maintenance of farm or stock ponds, acequias, or irrigation ditches, or the maintenance of drainage ditches. Let me just, maybe I can shortcut that whole thing and say, if the federal government has never required permits for or facilities on MRGCD property, is that same principle going to apply under the new rules?
I think I answered that question. Our exemptions mirror the federal exemptions. So we are trying to align the exemptions that have been in place for 50 years under the Clean Water Act.
Okay. All right. Well, let me ask you this question then, and that's very helpful. Of course, we stress about the specific language of rules because you may not be sitting in that chair in 10 or 15 years, and so we want to make sure we get the language. Under that language that I read to you, the construction or maintenance of irrigation ditches, so that is construction or maintenance of irrigation ditches, is fully exempt, right? It says construction or maintenance of farm or stock ponds, acequias, or irrigation ditches are exempt, right?
That's correct.
It goes on though, it says, or the maintenance of drainage ditches, and it omits the word construction, right?
Yep, that's the Clean Water Act.
Well, I understand. I'm trying to understand what this means. So let me, again, an example. After high flow events on the Rio Grande, sediment is deposited in MRGCD's ditches, reducing their capacity and creating a flooding risk. You're aware of that phenomenon, I expect. Yes.
Yes.
And I think we agreed before that MRGCD must dredge those sediment-filled drains quickly to restore their capacity to prevent flooding, right?
Yes.
So the question arises: is that post-flood dredging considered maintenance, which is exempt, or is it construction, which is unclear?
I would consider it maintenance because the ditch already existed. You're not creating a new ditch, you're maintaining it.
Okay, and so under those circumstances, the exemption would apply.
I would believe so.
And I have the same question I've asked you multiple times. Is the department amenable to potential language that just sort of clarifies that issue?
Again, it could be, I don't know if it depends on what the commission would want, if they want it in rule or again in the guidance documents on how we implement or agreements between NMED and MRGCD. There's different ways of approaching that issue.
Yeah, again, that's fair. I think you've heard from a number of the regulated communities through your testimony that people don't know what to make of guidance until we see it, of course, right? So
right, and rules can be interpreted different ways. You can read a sentence, I read it one way, you read it another way. So it's still going to need some sort of implementation practice.
that's true. One last exemption. This one's in B5. This is 20.6.2, 2303 B5. Exempts, the quote is construction or maintenance of farm roads, forest roads, or temporary roads for moving mining equipment, where those roads are constructed and maintained in accordance with best management practices. I paraphrased that last part, but you see that exemption.
I do.
And so the with regard to the roads, the exemption is limited to farm roads, forest roads, and temporary mining roads. Is that right?
Yes.
Are you intending to adopt guidance for the term farm road?
If it's needed, yes. If there are questions or concerns, we can certainly do that.
As it's currently drafted, the rule doesn't include other types of crossing, residential driveways, public streets, recreational trails, or utility lines, right?
No, again, these are taken directly from the Clean Water Act.
But of course, MRGCD, the other irrigation districts, and even say acequias often have these kinds of things crossing their facilities, right? Driveways, public streets, etc.
Yes, they're typically intermixed with urban areas.
And
Or
again, the Mr. Kasuga describes that there are 2,765 total culvert crossings in MRGCD's right of way. And And they have never been required to obtain a 404 permit for any of those. Are you aware of that?
I believe that's what he said in his testimony.
No reason to disagree.
Again, I review our nationwide permits, but I don't know every single individual permit under, permittee who is under those nationwide permits. So I would trust what you're saying, but I have not confirmed.
Fair. And I'll just represent to you and to the commission that actually, I think it's MRGCD 3 is that jurisdictional determination that we talked about earlier. And I believe it actually had to do with a residential road, and the board made a determination that those did not require a permit.
Mr. Wexler, we need a break soon.
Happy to take a break. Let me just see, because I might be done.
Okay,
In fact, let me just top it off, and then
all right.
done. And I just again to close that line of questioning, Mr. Armstrong and you have made clear that the intent of the rule is basically to maintain the status quo with regard to MRGCD. Is that right?
To maintain the status quo on exemptions, yes.
Thank you. No further questions.
All right, thank you very much, Mr. Wexler. That was 37 minutes into the agricultural district time. Let's come back at 10:45. Let's see, we have the department panel at the table. Hello.
Hello, I'm Sarah Stevenson with Carlsbad Irrigation District.
Thank you so much. Go ahead.
Good morning to the commission and to the panel. I'll only have a few minutes of questions for you. My name is Sarah Stevenson. I represent the Carlsbad Irrigation District. Are you familiar with Carlsbad Irrigation District or CID?
I am.
Okay, and so CID, you may be familiar, has approximately 35 miles worth of canals, approximately 200 miles worth of ditches, and approximately 20 miles worth of drains on the lower Pecos in Eddy County, New Mexico. Does that sound correct?
Yes.
And are you aware that CID is not now and has never been subject to the Clean Water Act or Section 404 permitting requirements?
I will take your word for it. I don't know.
Okay, thank you. And we will hear some more about that from our witness, Coley Burgess, next week, I believe. While Mr. Wexler limited his questions on Nichols, the Ninth Circuit case, I did want to come back to a couple points in the Nichols case that you referenced, if that's all right. And Nichols, as a reminder, was discussing the composed entirely language in the definition of point source and in the agricultural exemption. And that Ninth Circuit Court of Appeals referenced a couple of policy concerns in using the language composed entirely for any drop of water that was not agricultural return flow, of removing that exemption. So I just wanted to raise those policy concerns that were discussed and get your thoughts on them. And so the first one was, in this case, the EPA, but the regulating agency would face a heavy burden of issuing permits for irrigation return flows. Was the amount of permits that may need to be issued if all irrigation return flows were considered a reason not to subject the irrigation districts to the new rules?
Can you restate that?
Sure. In Nichols, the Ninth Circuit was concerned about the heavy burden on the EPA in having to issue permits if irrigation return flows were subject to the permitting requirements. Was the burden on NMAD to issue permits to the irrigation districts for all of its ditches or drains a reason to maintain the agricultural exception?
I believe we have, as agricultural return flows are one of the exemptions.
Another policy consideration the Ninth Circuit raised was, and this perhaps does not apply in New Mexico at all, was that it would be unfair to not apply the exemption if farmers who got their irrigation water from ditches were burdened, whereas farmers who got their irrigation water from, or their water from rain for their crops were not burdened. Again, as I note, that isn't really a concern in New Mexico, but do you agree with that policy discussion by the Ninth Circuit?
I'm not familiar with all of that, so
Okay.
I don't know if I can comment on that.
Okay, and just the final policy consideration that the Ninth Circuit raised was that the EPA in that case would be saddled with the quote, virtually impossible task of disentangling commingled pollutants, unquote. And so is that policy consideration of it being virtually impossible to consider where each molecule of water came from a reason to maintain the exemption?
It's, so when we looked at it, the flows that are going into those return flows are either non-point source, which are non-regulated, or potentially a point source, which would have a permit. So any other agricultural, like truly agricultural return flow that's commingling with that is exempt. It's the other discharges that may need to get permitted that are going into those return flows, right?
Thank you very much. Changing subjects now, am I correct in understanding that the department has not analyzed the number of hours it may take a potential permittee to comply with new permitting requirements? Is that correct?
I'm not quite sure I understand that question.
I'll try and rephrase. I believe we heard yesterday, I believe it was from Mr. Connolly, that it was expected to take the department approximately 400 to 500 hours to issue a permit. Was I correct in that understanding, Mr. Connolly?
That is correct. It varies. That's a kind of a long-term act. There are permits that will be significantly than that.
Okay, thank you. And did NMED look at the number of hours it may take a permittee to submit the permit application, undertake any studies that may be required?
We, for our exhibit 79, we have for individual permits requiring at least 180 days prior to commencing the discharge, applying once the rules are in effect. For a discharge that has commenced prior to the effective date of the rule, the discharger shall submit an application within 90 days. So it's already in effect, it's discharging. So within 3 months, working to apply for a discharge permit. For the other general permits, we have that temporary authorization, which has similar, not similar, but like requirements for if a discharge has not commenced or if a discharge has commenced, what the timelines are.
Okay, so you think at least 90 days would be sufficient for a permittee to submit an application after the rules are promulgated, correct?
Yes.
And do you have an estimate as to the number of hours it will take a individual permittee to prepare the application?
I have never prepared an application, but other permittees have, so that might be a question for other permittees.
Okay, and Mr. Connolly, may I ask you if you have any estimate based on your past experience of the length of time it takes a permittee to prepare an application?
It would be highly dependent on the permittee and type of facility, what forms they're submitting. But if they do it routinely and the person filling out their application is very familiar with the facility, it could take 8 to 16 hours. That's a lot. I know what the forms are. I've looked at them a lot, so I'm trying to think about that. For others, it may take significantly longer, and there are certain applications that are very long, and I suspect would take many times that. I'd hesitate. And then for an NOI for a general permit would be on the lower end of that, even less than that. But I mean, I would suspect some of these could be 80 plus hours. And if they want, it depends on what you say. Does it mean as application? If they are submitting a special study with the application, say they want to expand their discharge capacity and need an amplification, that would be considered part of the app. That could be considered.
And that may be part of the additional information that we need. They submit the basic application and we work with the permittee. Again, this is a new permitting program for everyone. We're planning on providing compliance assistance and training on how to do things for the regulated community and for our own staff. So it's going to be a learning process, but that intent is to, if you're discharging, get your permit in, and then we'll work through the permit process with you.
Okay, that's all I have. Thank you very much.
Thank you, Ms. Stevenson. Mr. Domenici?
Good morning, Madam Hearing Officer, Mr. Chairman, members of the commission. I represent the Elephant Butte Irrigation District. And I just have a couple of questions. But first of all, we have a lot of similarities with the other irrigation districts, especially with MRGCD in the sense that we have both urban, suburban, and rural property owners adjacent to us. But really the biggest difference that we have from MRGCD, for good or bad, is that we are much closer to Texas. And I'm not sure if you're aware, but New Mexico just settled a long drawn out lawsuit with the state of Texas. Are you aware of that?
I'm familiar with our obligations to deliver water.
And with respect to those obligations, are you aware that as part of the Supreme Court approved consent agreement, there is actually an operations settlement agreement by which Elephant Butte Irrigation District operations are used to deliver water that Texas requires to Texas?
Am I familiar with the settlement? I know of it. I don't know the details.
So the structure is there's an agreement to provide surface water to Texas, and then there's several internal contracts how we're going to do that. And one of those is called the Operations Settlement Agreement, which involves the operations of Elephant Butte Irrigation District, the Rio Grande project, and it's signed off by the state of New Mexico to deliver water to meet New Mexico's obligations to Texas. And the reason I'm bringing this up for you and the commission is you indicated you're willing. So first of all, you indicated that the intent is to maintain the exemptions that have been in place and the interpretations of those exemptions that have been in place for the last 50 years or so, correct?
That's correct.
And I just want to reflect to you that the Operations Settlement Agreement expects to be able to rely on those exemptions so we can continue to operate and deliver water to Texas. So given that, would that be additional motivation for you to consider language? I think Mr. Wexler asked you about that. Language that might clarify these exemptions to provide more reliance or more foundation for the irrigation districts that these exemptions will in fact remain in place.
I did not see, I don't remember. Well, there may be some. I think that would be up for the commission to decide if they want to accept additional substantive language regarding that in the exemptions.
Well, I'm talking about Mr. Wexler asked if the department would consider definition changes with respect to some of these issues, and I think you indicated the department would consider that as the hearing proceeds.
If the definition, again, without knowing what the definitions are, have no idea if we would be in support or opposed.
Okay, and so my question was, if the need for the irrigation districts to have language to maintain this intent that you've described, the intent to maintain the exemptions that have been in place, if that is not only supported by what the irrigation districts do in terms of the ag community, but with respect to my client, also with respect to delivery of water to Texas to meet New Mexico's obligations. Would that be another reason to try to maintain that status quo and that certainty out into the future?
Yeah, I think I've stated multiple times that our intent is to maintain those exemptions that have been in existence.
Okay. And I'm not going to go through it, but you probably had a chance to look at the notice of intent of Josh Smith, who's the manager for Elephant Butte Irrigation District, at least briefly.
Mm.
And he identified some of the basic amount of acreage, the distance, the crossings, that information. Do you recall
Yes.
that?
Yes.
Okay. And you understand that we have, again, we're not as big as MRGCD. We're similar to all the irrigation districts, and we have similar issues as all of them. Would that be fair to say?
Yes.
Okay. Thank you. That's all I have.
Thank you, Mr. Domenici. Is there anyone else representing a party among the group we are referring to as the agricultural districts? No? All right. Ms. Richards would ordinarily be next, but she asked for a little bit of grace there. Ms. Dolan, do you have questions of the department panel?
Forgive me, I might be able to benefit from a bit of grace myself, but I'll give this a whirl. If these questions are better directed to other other witnesses, please let me know. Again, I'm Maureen Dolan. I represent Triad National Security. I just have a couple of very quick questions, I believe, for you, Ms. Lemon. Are you familiar with the limitations provisions in 20.6.2.10?
Yes.
So are you also aware that under the state's current regulatory regime under the state's Hazardous Waste Act and Clean Water Act, that I'm going to read the beginning of current section A of 20.6.2.10 that, quote, any activity or condition subject to the authority of the Environmental Improvement Board pursuant to the Hazardous Waste Act and Groundwater Protection Act or the Solid Waste Act, etc., except to abate water pollution or control the disposal or use of septic or sludge is a condition or activity to which the Water Quality Act does not apply. Forgive me because it's a fairly complex kind of interaction among statutes and regulations.
Yes.
Are you aware that under the current regime that if a Clean Water Act, a federal NPDES permittee has a wastewater treatment unit exemption under the Federal Clean Water Act, then under this regime, the Hazardous Waste Act does not apply under this limitation statute?
Yes.
Is it the state's intention to continue a similar regime if a current or if a permittee is a permittee to for example, an intermittent stream segment?
If there's a permit under the Hazardous Waste Act, would we want to permit? Is that what you're saying?
It's a complicated question, and I apologize for not setting it out more explicitly and carefully. it is my understanding that it is possible that some permittees who are currently permittees under the Federal Clean Water Act may need to become permittees under the new state regime, given these changes, because upon renewal, if they are discharging to a non-perennial breach, for example, they may need a state permit rather than a federal, or a permit under 20.6.2 as opposed to 20.6. Is that possible?
There's two things. One, we recognized you're talking about 20.6.2.10, correct?
Yes.
In that subsection A,
Yes.
the surface water discharge permit phrase at the beginning, we should not have included. What we were trying to do was for the oil and gas, the NMOGA, the Oil and Gas Act, there are some discharges. So that we're intending to, we agree that it's a problem, but our exemptions also cover if there's another federally or state issued permit, part of that, it will be exempted from a surface water discharge permit. So the exemptions in 2303, 2302, I'm currently in 10, so let me see what the exact. 2303, there are exemptions for if the discharge has a state or federally issued permit already under a different program.
Okay. I think I'm getting at something slightly different. I am trying to understand that if upon renewal of a water discharge permit that is currently issued under the Federal Clean Water Act, and it becomes a discharge under the state regime under 20.6.2 would be, and so that there was no longer a Clean Water Act exemption.
If it's under the federal NIFTY's program, it would come through to us under 20.6.5.
Right. Right. I'm kind of trying to capture two different scenarios. So that I understand, but it seems like there's a possibility for currently permitted entities under that regime, under the federal regime, to actually change. I think that's something, corrects me, that you have acknowledged that there is the underlying assumption for these rules is that there is going to be a change, that there's going to be a loss of federal coverage. Is that correct?
Yeah, but if there's no loss of federal coverage, we're taking over the federal program. So that federal permit will come to the department under the NMIPD's program in 20.6.5.
Okay.
We will have state protection similar to our 401 certification of those permits, right?
Yes.
But it will be under that NMIPD's rule and NMIPD's Act.
Okay. What about the circumstance in which the discharge is not to a perennial water?
If it is not a NMIPD's permit right now,
if it is a current federally regulated discharge to an intermittent water.
If it's a federal permit, it will continue to be under the NMIPD's program, right? Because EPA is recognizing that it is a Discharge to a water of the US,
Okay.
essentially.
Thank you. And just to go back to something that you had mentioned about the amendment to 20.6.2.10, are you referring to the amendment that you proposed? Forgive me, I don't know whether it was first proposed in the
It was-
exhibit 79.
It was in our first amended petition as
Okay.
exhibit 28.
Okay,
It did not change in exhibit 79.
Okay.
But we recognize that we missed a change that we needed to make.
okay. So are you, forgive me, are you proposing that you will strike the initial current red line that says except for a surface water discharge for which a permit is required in Part A?
That's correct.
Okay. I think that's all I have. Thank you.
Thank you, Ms. Dolan. Mr. Maxwell, if you're on the platform, do you have questions of the department panel? Luis, is he on the platform? Okay. Mr. Weatherby, are you on the platform and do you have questions of the department panel? All right. Mr. Kermsey? Okay.
All right, thank you, Madam Hearing Examiner. Thank you, Mr. Chair, and thank you to the commissions. My questions are quite limited today, but they'll mainly be for Ms. Lemon. So, good morning, Ms. Lemon. Ms. Lemon, you stated in your testimony that water quality is critical to the continued health of our citizens and the future economic development of our state. Clean water means healthier New Mexicans, correct?
Yes.
And Ms. Lemby, you stated in your testimony on page 8, the intent of the proposed regulations were to use practical and common sense approaches to ensure clean water for drinking, agricultural, recreation, cultural, and other uses. Correct?
That sounds like something I would say.
Yeah. You have no reason to disagree, correct?
Yes.
Awesome. And Ms. Lemon, is it fair to say that NMAD supports permittees who voluntarily improve their water treatment and filtration technology during the life of the permit?
Yes.
Ms. Lemon, Ms. Lemon, you also stated in your testimony at the bottom of page 26, top of 27, that modifications require submitting all information necessary for evaluation of a new permit when the permittee is proposing changes to contaminants, correct?
That is correct.
And that refers to the proposed section 2304D2 that's in part 2.
Yes.
Great. And by the contaminants in your direct testimony, you mean the defined term water contaminant, correct?
Water contaminants.
Yeah. And water contaminant means any substance that could alter, if discharged or spilled, the physical, chemical, biological, or radiological qualities of water, correct?
I believe it's defined in
Yeah.
0.6.
Yeah, in the statute.
So,
yeah.
Yeah.
Hold on.
Oh, apologies. Yeah.
Let her answer.
Yeah, you agree that it's in the statute and in the regulation.
That's correct.
And That definition is not limited to harmful substance. A substance that improves water quality still alters its qualities and so still meets the definition, correct?
I did not follow that question.
So I guess I'm getting at the alters water quality. Can a contaminant alter it positively and negatively? Or negatively, not at the same time?
Can a contaminant alter it positively?
Yes.
No, I would argue no, because a contaminant is a contaminant. The treatment may alter it positively because you're removing more contaminants.
Okay. Let's see here. So after that comment, a permittee who modifies the discharge of an existing water contaminant that they have to improve the quality of the discharge would not need to apply for a permit modification?
Um, I'm not sure. If you're changing the treatment scheme of your treatment plant, I believe you would need to apply for a modification.
Okay.
I think if you're wanting to discharge more and treat more water, you would have to apply for a modification. So if you're changing the basic details of your discharge, you would need to apply for a modification.
And that's even if it is improving, so less harmful substances are going into the.
Yes.
Yeah. Okay. And that modification must include all the information necessary to evaluate a new discharge permit, correct?
That modification, it says all the information necessary for evaluation of a new discharge permit.
Okay. Right. And that would also require the person who's improving their discharge to remove contaminants to pay a $25,000 fee, even though the receiving water is no worse off.
There are opportunities to request fee reductions. I would assume that that would be, since it's a net positive, something that the department would consider.
Okay. And so if someone did make these improvements and did not notify the department, is it true that the secretary could terminate their permit? That's under 2314D2.
I don't think I covered this section in my testimony 2314. That may be better suited for Dr. Fuad or Miss Susan Lucas Kamat.
All right. And you testified at the bottom of page 6 on your direct testimony, I believe, that the surface water permitting regulations are patterned from NMED's log-standing groundwater permitting program, correct?
They were tailored after the structure of the groundwater permitting program. That's correct.
And are you aware that the groundwater discharge modification rules, that's at part 23106, that applies only to changes in the discharge of the specific water contaminants in a list in that area of the regulations, or a toxic pollutant, not any water contaminant?
I'm not, I don't permit groundwater, so sure. If you're reading from the rule, I will say that the surface water discharge permitting program was, like I mentioned, the framework of the Groundwater Quality Bureau's permitting program, but also aligning it with the NMAC's program. So we're using both and making sure we're aligned with the NMIPD's program. So the NMIPD's and the state program are aligned, and permittees won't know which permit. Essentially, that's the design. Now, whether they do or not, but having the same type of procedures and processes for both programs is what we're intending.
Okay, great. And permittees are subject to monitoring requirements during their permit, correct?
Yes.
If these monitoring requirements reveal the permittee is overperforming in its treatment, would it be required to file a permit or to file a modification?
If it's achieving its effluent limits, no.
If it's exceeding them, as far as not, I guess I'm reading it in a different way. If it's overperforming, meaning it's removing more of the harmful contaminants than expected.
I don't think that requires a modification.
Okay. If a permittee, this might be for Mr. Conley as well. If a permittee is in excellent compliance with their permit, are there any cost savings in the fee structure if they renew?
There is a provision for waiver of or reduction of fees in Exhibit 79 A and B.
All right, I'll move on to a new topic. So I've heard this phrase a few times in the NMAC testimony, and I thought, Ms. Lemon, you'd be the best to answer it because you are an expert in hydrology. So the phrase, it was in your testimony on the last paragraph on page 10, and it says, I think at the beginning of that last paragraph on page 10, it says, research shows that ephemeral streams are the capillaries of a watershed, correct?
Yes.
And what research are you citing to in the record?
I think I have NMAD Exhibit 37.
Okay.
That's the research, which is a EPA document with some researchers that looked at ephemeral and intermittent streams and their hydrologic and ecological importance in semi-arid systems.
Okay. So yeah, I saw that it was used once in that exhibit. It appears on page 52. And that quote references groundwater, not ephemeral streams, correct?
What quote are you talking
So
about?
it says,
On 52?
yes, page of exhibit 37. I can read the sentence if you, oh, sorry.
Okay, 37.
Yes, I believe it's page 52.
Okay, page 52.
Top.
Okay.
Did you find the
On
sentence?
that page, yes.
Okay. Well, the sentence reads, it's describing moist stream banks fed by capillary flow from groundwater as sites for turtle and insect reproduction.
I don't know where you're at. Are you in the hydrological habitat features or faunal
I
abundance and
I believe so. Yeah, I don't
distribution?
have it. Sorry.
Mr. Crimsey, please.
Okay. Channel flow is a visually prominent aspect of the hydrological characteristic of a stream, but it is seldom the only hydrologic habitat feature of biological significance. A stream may also possess moist banks fed by capillary flow from groundwater, which offers sites for turtle and insect reproduction, a hyperrheic or subsurface zone, which is part of a stream system, flow with a distinct invertebrate fauna may underlie a dry stream bed. So there are the capillaries in this sense are for the hyperrheic zone from the groundwater, but there are capillaries when you look at like an aerial view of a watershed, the capillaries feeding the larger systems usually are ephemeral waters coming in and feeding the larger river system. That's what I was thinking about, not this specific instance of a hyperrheic zone.
Okay. All right, we'll move on to another topic. Ms. Levin, at page 26 of your direct testimony, the last full paragraph, you stated that for discharges that may significantly degrade a high quality surface water, applicants must provide an alternatives analysis, correct?
Direct testimony
Yes.
for what page?
26.
Can you repeat it?
Yes. For discharges that may significantly degrade a high quality surface water, applicants must provide an alternatives analysis.
That's correct.
And this is the requirement in the proposed rule 2304C1G, correct?
Yes.
And in that proposed rule, I think there are two terms that you had mentioned before. Sometimes people can disagree in what the terms mean when reading this, reading the regulation. And the two terms I see are significantly degrade and high quality surface water. So to start, where can I find the definition of significantly degrade?
It's usually a term that is in regulation and interpreted through implementation.
Okay.
Significant degradation is, I would look at in our anti-degradation policy or the significant degradation threshold.
And is that the same for the definition of high quality surface water?
High quality surface water is a surface water that is meeting its water quality standards.
Okay.
Yes.
So high quality surface water would not be the same as in Exhibit 40, which I think is the anti-degradation analysis. Go back to the question. Sorry. So high quality surface water, would that be the same as high quality water in that Exhibit 40?
Exhibit 40 is the anti-degradation. That is how we look at it.
Okay. And these two terms define the threshold determination for which permittees must provide an alternatives analysis, correct?
Yes, significantly degrade a high quality surface water. So we're looking at anti-degradation.
Is an alternatives analysis or a non-degradation analysis a complex endeavor?
It may be, it may not be. It depends on the discharge, the surface water, what you're trying to protect, the aquatic resources. So it can be something that's relatively simple, and it can be really complex depending on the discharging project.
And in your rebuttal testimony on page 49, you also describe the distinction between what regulations do and what guidance documents do. You state regulations describe the requirements, processes, and legal obligations that apply and set enforceable boundaries, while guidance documents translate regulatory requirements into technical procedures, correct?
I believe so.
There's no reason to disagree.
No.
Okay. And under your description of the regulatory framework, guidance documents translate regulatory requirements into technical procedures. They do not themselves supply the legal obligations, correct?
I'm not sure if it's technical procedures, but it's definitely how we implement the regulations. Yes.
So in the case of this regulation we're talking about, 2304C1G, the guidance isn't necessarily providing technical procedures for implementing, but it's supplying the definitions to determine whether a regulation attaches in the first place, correct?
I didn't follow that question.
So instead of describing how a definition in a regulation is operating, it's actually providing the definition for the threshold conditions.
I don't know I don't know what, again, how that question, I'm not understanding the question.
Okay. So let me get a second to rephrase it. So in this regulation, there's two terms that are, as we agreed, ambiguous and require a guidance document. Those terms are not defined in the regulation.
Guidance document?
Or did I misspeak? So let me try this again. So in the regulation that I mentioned, there are two terms that are ambiguous, and they're not defined in the regulation in part 2 or part 4. They're actually defined in a guidance document, but they also operate as the threshold to determine if this person will need extra permitting requirements. So my question is that guidance document actually setting a regulatory obligation rather than implementation?
That I would argue that the guidance document is part of the regulation under our anti-degradation policy and implementation plan, which that is approved by this commission and goes through public review and participation. So it is part of the whole process. And I think part of the regulations, because we have an anti-degradation policy and implementation plan in the regulations that the commission approves.
Okay. So the guidance document is aiding in enforcing that boundary.
It's implementing the regulations. It helps to show how we're implementing the regulations.
Okay, so someone wouldn't know whether they have a high quality surface water or if they're significantly degrading without that document.
That's correct, but the document is publicly available and again, approved by the commission and part of our whole water quality management plan, continuing planning process that we undergo to implement these regulations.
Okay. Okay, thank you for that. I know we were in the weeds a little bit for that one, but I'm gonna move on to just a few more broader questions, and then we should be done here. 1 second. Okay. In the proposed rules, it contains, so Exhibit 79, it contains standard permit conditions in section 2307. Will individual and general permits all contain these conditions?
There's different sections in 2307 applying to individual and general permits. So there's a section that will require every individual and general permit to have certain things if it's applicable to that type of discharge. And then there's point source requirements or conditions and dredge and fill requirements or conditions.
Will the permit conditions be limited to those in that rule? Or those rules?
For the permit, but based on the specific discharge, there may be additional requirements depending on the discharge or the activity.
Okay, and that's at NMAD's discretion?
No, that's based on the water quality standards and regulations.
Okay. And then the last set of questions I have for you, in the proposed exhibit 79 in part 2, 1220 B and C, the department proposes to allow the use of credible information received from third parties as a basement of enforcement. Is that correct?
Credible information, yes.
How will the department determine that information is credible?
Just as we would when we evaluate any information that comes to us, we look at quality control, quality assurance. We look at different values on how the data or information were received. So there is a process right now where we receive information, we receive data, we go through a process to evaluate that to see if we can use it or not.
Okay. So will the department apply the same standards for this credible evidence as it would to data collection by a permittee applicant?
I'm not sure if it's evidence, it's information.
Okay.
I think of evidence as like more formal, like legal procedure. This information, yes, it would be similar to data that's collected under a permit where you have certain controls and analytical methods that you're following to ensure the data quality, right?
Okay, so the critical information would there be some standard of like this needs to have some formal investigation. So there had to have been some third party formal investigation to go into this this complaint to say to the permittee.
We always evaluate. I mean, when we get complaints, we're looking at whether it's credible or not. We go out and do inspections. If we're not sure, we do site visits to see what's on the ground in reality. So there are confirmatory steps that would apply to that.
Okay, so the step would be you get some credible information that has, definitely the department would see if there's some validity to this because it seems to the standard similar to an application, and then they follow up on those before there's an enforcement.
That's correct.
All right, well, that's all my questions. Thank you so much for your time. Thank you much, NMED, and thank you, Chair, Commissioners, Madam Hearing Officer.
Thank you, Mr. Crumpsey. Ms. Miller, do you have questions of the department panel? Hooray.
Can you hear me now? Good morning, Commissioners, Madam Hearing Officer, and panel. My name is Susan Miller. I represent Affordable Solar and GridWorks, and I just have a few questions for Ms. Lemon. My clients are concerned about the continuity of their permitting and the timing of implementation of new construction general permits and timing of authorizations on notices of intent. So a lot of my questions have already been asked, but I just want to have a few clarifying questions. Looking at Exhibit 79 under 20.6.2.2303, what was added to subsection A4, it appears that the department is supportive of a proposed change, providing that if one has an NMPDS permit issued under 20.6.5 or a federal permit, a federal NIPDES permit, that the department is certified under section 401, such permittee does not need a surface water discharge permit. Is that correct?
That's correct. Under this rule, they would already have a state or federal permit.
Okay, great. And you may have addressed this in your answers to some of Ms. Dolan's questions, but I just wanted to clarify. Under the proposed rules, when New Mexico is awarded primacy over NIPDES permitting, can a facility continue to discharge pursuant to a federal NIPDES permit until that permit expires?
Yes. So when we apply to EPA and EPA grants us approval to or authorization to administer the program, there will be that memorandum of agreement that I've talked about between the department and EPA, which details how the program will be phased in over time. The dischargers who already have permits and they're discharging under those permits will continue to discharge under those permits until the permit is up for renewal. Then you submit the application to NMAC based on that memorandum of agreement. It again, on day one of authorization, we are looking at, the 5 NIPDES program components. Those are going to be phased in over time. So hypothetically, let's say we're going to have municipal wastewater treatment plants first. As those permits come up for renewal in that year one, they're going to come to the department. And then over that 5-year term, we're going to collect all of the municipal wastewater treatment plants. In year 2, we might move to general permits. And those general permits would continue in existence until the general permits are up for renewal. Then we would take those over. But you can continue to discharge under that general permit coverage. And then, so it'll go. So the whole phasing in will take not just 5 years, but probably 7 to 8 or 9 years, because we're taking over 5 programs over consecutive years and over different permit terms.
Sure. Okay. And so if during this switch over, once you get primacy, let's say their NIPDES permit expires, but before the state adopts its own general construction permit, is what the department is proposing, is that you could apply for a temporary permit?
So under the NMPDS program, I believe what would happen is that timeline is a little bit different than the state program with the temporary authorizations, because I think we would be ready for the general permits, because we're going to get authorization, but we may not take over general permits until year 2 or year 3. We have that time already baked in to develop the permit and get it issued on time. So those permittees will be able to come and apply to us for coverage. Does that make sense? Whereas the state program doesn't have that timeline, the same timeline.
Okay, I understand. Thank you. And just for clarification, section 20.6.5.101A, permitting prohibitions and requirements. states that no person shall discharge a pollutant to a water of the United States from a point source without a permit issued by the secretary or general permit coverage approved by the department under this part. It does not expressly give an exception to facilities that have federal NIPD's permits that haven't expired yet. Was that the intent, to provide an exception?
Again, it will depend on our authorization for the program. So you can continue to discharge under an issued NIPD's permit, and based on our memorandum of agreement with the Environmental Protection Agency, when that permit comes up for renewal, then you would come to the department for that permit instead of to the EPA. So you are still covered if you're under that federal NIPD's permit.
Okay. You testified yesterday that the earliest the state could expect to obtain primacy is December of this year, but if everything goes smoothly.
That would be for applying to EPA, submitting our application packet.
Oh, so the actual completion of that process would be much longer.
It would
what you're
be
anticipating.
in 2027.
And you're not sure exactly when you will issue your general permits, but it'll be after that.
That's correct.
Okay. Okay. And I don't want to beat a dead horse on the definition of surface waters of the state. I just had a couple of questions about the protocol that you talked about yesterday, the hydrology protocol. And I thought I understood that the department is currently using that to determine what constitutes perennial water versus intermittent versus ephemeral. Is that right?
Yeah, we look at it to apply standards because we have standards for ephemeral, intermittent, and perennial streams. And so we use that to identify which standards to apply.
Okay. And are you going to continue to use that?
Yes, we have that tool. That's probably not the only tool we'll be developing to help implement the program. But you know, we have some rapid assessment methods for wetlands that have already been developed that we're looking at applying to permitting with some modifications. We're working with some contractors for different tools that we can use to help with that, with all different surface waters, right?
Okay. Will that hydrology protocol be used for any other purpose other than to determine the difference between perennial, intermittent, and ephemeral? Or will there be separate guidance documents for that?
Or
in terms of determining what a surface water of the state is, are you going to be using that hydrology protocol for any other purpose other than to determine whether intermittent, perennial, or ephemeral?
so the hydrology protocol is one of the tools. We're also, as I mentioned previously, creating a map to help with looking at a project area or where a discharge is going to occur. So looking at things in combination, if there are still questions, going out and doing a site visit, but that hydrology protocol is just one tool, but it is specific to looking at like the flow of a system, whether it's perennial, intermittent, or ephemeral.
Will it be used to determine what a sand flat is, or a mud flat, or playa lake, or any of those?
That's
define further those definitions.
No, it's more of looking at the permanence of flow.
Okay.
not identifying the type of surface water.
Okay. Thank you. And my last set of questions pertain to general permit conditions under 20.6.2.2306E and 20.6.5303C. And I believe we're in alignment with the department on these issues, but do you agree that the permitting action under 20.6.2 or 20.6.5 is the issuance of the general permit and not the authorization of the NOI under the issued general permit?
Can you point me again where you're looking? Sorry.
Yeah, 20.6.2.2306E and also 20.6.5.303C.
In exhibits 28 and 29, or in exhibit 79 A and B?
Well, I guess like it's just a general question.
Okay.
Whether for construction, for example, any kind of general permit, including a construction general permit, the permitting action is approval of that permit itself and not the authorization of the NOI, correct?
Yeah, for the public.
For public comment purposes.
Right now, yes, that in the proposed rules, it is the draft permit and the actual general permit that goes through that public comment period. The NOIs are submitted to the department for review and confirmation that the discharger does meet eligibility for the general permit. And then we will post a list of all of those NOIs that have been submitted to the department or that have been approved and that have been terminated.
Right, okay. And do you agree that allowing a petition for review of an authorization of an NOI does not align with the Water Quality Act, the NMPDES Act, or with federal regulations?
It would be different than what is currently happening under the federal regulations. I think it would be definitely burdensome for the department because we have thousands of permittees that are under general permits. And so having notice of all of those as they come in would be very difficult.
And allowing such a public comment process or an NOI authorization would compromise the timeliness, the timely approval of such NOIs, correct?
It would likely extend the approval time. And I believe that Dr. Fuad goes through the public participation process in his testimony. I didn't really cover that in my testimony.
Okay, I think you referred to it briefly, but he went into more detail. Those are all the questions I have. Thank you so much.
Thank you, Ms. Miller. Let's take a lunch break, come back at 1 o'clock for public comment, and then I'll call on Ms. Richards. 2574. This relates to surface water permitting programs. We have reserved 1 o'clock for an hour each day of the 9-day hearing for public comment. Before I start calling names, we'll call on those here in the room and also on the platform. Let's see, there you are. Ms. Taylor has something she'd like to say to everyone in her email contact list.
Good afternoon, everyone. I just wanted to let you know that I discovered over lunch that my email had been hacked. And so you might get an invitation from me, especially those that were on our group for the lawyers for this hearing. Do not open it. Please just delete it. And I apologize. And tell others that aren't here right now that they might get a scammy email from me. So sorry about that, but thank you.
Thank you, Ms. Taylor. Alrighty, just a few things about non-technical public comment. I will ask you to come to the front desk here to press the button to turn the button green. Unless you're speaking into a microphone, the people on the platform cannot hear you. I will ask you to spell your first and last name. Commission rules require that anyone speaking is put under oath. And I will ask you to keep your oral comments to 3 minutes. Or you can do what Teresa Seamster did and submit a written comment or both. But oral comments really do need to be limited to 3 minutes. We have just a lot of moving parts in this hearing and a lot of interested folks and 28 technical witnesses. So we didn't have a sign-in sheet at the back of the room, right? No. Okay. So I'm going to have to do this by show of hands. I'm going to sweep from this side of the room to that side of the room. Who here, like starting on this side, would like to offer non-technical public comment? Raise your hand. Okay. Gentleman in the white shirt, in the blue shirt. Okay. Start with the two of you. You can even come up simultaneously if you'd like. Yeah, go ahead. Sit. If you sit down, the microphone can hear you. Bernard Green, would you spell your first and last name, please?
My name is Jeff Harrell, Jeff Harrell.
Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. Please go ahead.
Thank you. Once again, my name is Jeff Harrell, and I'm from Rio Rancho. I'm not a native New Mexican. However, having lived in 10 different states and 2 foreign countries during my 29 years of military service, it was New Mexico as the place we decided 20 years ago to make our permanent residence. We did it for several reasons, but probably the most prevalent or most important was because of the outdoors. The vast amount of public lands, the beautiful mountains, and the clear, cold running streams and rivers. I hike and fish these waters every week, and as the president of the Bosque chapter of Trout Unlimited, I've used them to teach fly fishing and appreciation for the outdoors to more than 150 people so far, to include veterans, youth, and breast cancer survivors. Our waters are important to me. While Senate Bill 21 is a big step in addressing the loss of protection from the Clean Water Act, it will take strong implementation rules to protect our waters. Please consider these 3 requests. As someone who spends countless hours outdoors, I ask that these rules protect all surface waters across the state, including the smallest of tributaries, which often hold the Rio Grande cutthroat trout, our state fish. As someone who not only fly fishes every week, but who continues to preach the therapeutic values of this sport to so many who need it, I ask that you leverage the expertise of the newly reorganized Department of Wildlife in the permitting process. It is their expertise that brought the Gila trout back from endangered status and continues to ensure the survival of the Rio Grande cutthroat. Finally, as someone who works closely with nonprofits like Rio Grande Return, Amigos Bravos, New Mexico Wild, and of course Trout Unlimited, I ask for the permitting process for restoration be streamlined. I adopted New Mexico as my home state 20 years ago, and its resources mean a great deal to me. Thank you for your time and the opportunity to provide my comments.
Thank you, Mr. Harrell. Sir. Spell your first and last name. It needs to be green.
My name is Doug Reber, DougreaB as in boy, ER.
And do you swear or affirm to tell the truth?
I do.
Please go ahead.
As I said, my name is Doug Reber. I have been living in the state for the last 33 years in Albuquerque. As a professional, I was an environmental consultant for that full time, doing restoration work, coordinating with the New Mexico Environment Department and the Environmental Protection Agency. So, and in addition to that, I have been doing passionate fly fishermen for about the last 30 years as well. I'm very excited that Senate Bill 21 is moving forward. And I really just have a few things that I want to say. I do also believe it's incredibly important that we do protect all of our surface waters, including the perennial and the intermittent streams. I think that is crucial. As far as the permitting process goes for future activities, I believe that we need to keep our permitting diligent in new facilities and give the public the time to have input that I think is very important. At the same time, I believe it's also really important for us to streamline the restoration process. We all know that the permitting process can take up so much of our time. I think I've spent half of my career waiting for permits to get approved, and that is something I'd like to see worked on. I think our regulations going further, I think our regulations going forward should be at least as protective as the federal rules were previously. Thank you very much.
Thank you, Mr. Reber. Anyone else on this side of the room here to offer public comment? There will be other sessions, 1 o'clock every day. Nope. All right, let me move to this side of the room. I see a blue shirt, white blouse, and green. Yeah. Okay, 2 greens. Great. Sorry for the sartorial comment.
At least you didn't say rumpled blue shirt.
If you would spell your first and last name, please.
Jana, Jana, Gunnell, Gunnell.
And it's green there?
Yes.
Okay, good.
Can you hear me?
Yes. Do you swear or affirm to tell the truth?
I do.
Please go ahead.
Thank you, commissioners, for your work and for your time and for the opportunity to speak. Again, my name is Jana Gunnell. I am a medical doctor and I have a master's degree in public health. I worked for 30 years on northeastern Arizona, northwestern New Mexico, and in those 30 years, I worked with the Indian Health Service, the Navajo Nation's Health Division, and in the last 20 years, the New Mexico Department of Health. I'm now retired and live in Taos. I'm here to urge you to adopt strong enforceable rules for Senate Bill 21 to fully protect New Mexico waters. Safe, reliable drinking water is a fundamental human right and a cornerstone of public health. Our state is dry and getting drier. Access to clean water is already seriously limited in many communities across the state, and certainly in tribal communities. That's often the legacy of unrestricted dumping of agricultural and industrial chemicals and of radioactive waste. For decades, polluters were unregulated and unaccountable. Some have gone bankrupt. Many have simply walked away, leaving communities with contaminated water and soil, and with the resulting devastating health impacts. We must not ignore or deny this reality. We must face it and act on it. Senate Bill 21 establishes a state surface water permitting program to protect all of our surface waters, but it must have strong, comprehensive, clear, and enforceable implementation rules in order to be effective. Industry proposed rules are not based in demonstrable science, and they are not focused on protecting the precious water in our semi-arid state. They're about an easier, cheaper way of dealing with industry wastewater and maximizing their already massive. It's not just the contamination of our water and land that's of public health concern. It's the prioritizing of the demands of polluting industry over the health and lives of the people of our state and the health of the environment that sustains us all. Please remember the cumulative history of extractive industry pollution in New Mexico. Don't compromise the science or minimize the experience of impacted communities.
Thank you, Ms. Cannell. Just spell your first and last name.
Monica Rodriguez, Monica-Rodriguez.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead.
Good afternoon, Chair. Good afternoon, Commission. I am the Secretary of San Joaquin del Rio de Chama Land Grant. I am a governor appointee to the New Mexico Land Grant Council, and I also work for New Mexico Acequia Association as their community outreach coordinator. And I want to urge the Commission to adopt strong, comprehensive, clear, and enforceable rules that fully implement Senate Bill 21 to protect New Mexico's waters from existing and future pollution. Prior to my work that I priorly discussed, I worked 20 years for the New Mexico Judiciary, a body that's full job is to interpret and enforce the rules and laws of New Mexico. It's very important that SB 21 adopt the rules that protect water in our rivers to ensure our acequias flow with clean water, prevent pollution in our rivers by enacting effective and enforceable regulations, protect the full breadth of New Mexico's surface waters, including rivers, streams, wetlands, and the smaller tributaries and drainages that sustain them, and be at least as protective as lost federal protections, including considerations for agriculture. We have to ensure that robust public participation so New Mexicans have a meaningful voice in the decisions affecting the water. New Mexicans deserve clean, safe, and reliable water. I urge the Commission to act accordingly to pass strong, clean water protections that ensure a healthy and safe future. There are over 700 acequias in New Mexico that depend on clean water. I can remember a time when I was growing up on the La Mesilla acequia that I would swim in that water. Farther up, there was even a time that we would drink that water. I want to ensure that my grandsons can continue to use the acequia like I used it as a kid. And it wasn't that long ago. I'm not that old. So I do urge you guys to pass rules that are enforceable. Thank you for your time.
Thank you, Ms. Rodriguez. You would spell your first and last name?
My first name is Blake, B-L-A-K-E. Oh, my first name is Blake, B-L-A-K-E. And my last name is Lewis, L-E-W-I-S.
All right, you're just gonna have to speak up a little bit. Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead.
My name is Blake. Like I said, Lewis is my last name. I live in Cundio, New Mexico.
Get closer to the microphone.
Okay, is this better? I live in Cundio, New Mexico. I am a commissioner and parciante on the Placita, Acequia de la Placita ditch. I've lived in New Mexico my whole life. I have been blessed to work in the community. I'm an arborist by trade, so trees, plants, water, they're all interconnected. Our ecosystems are all interconnected. And I am here to advocate for SB 21. I urge the Commission to adopt strong and comprehensive, clear and enforceable rules. I just went fishing this last weekend up on the La Junta Creek and was able to catch a few fish in there, and just thinking about how blessed we are to have these clean water systems, including the rivers and the acequias, it's important to preserve those, and for us as New Mexicans to be able to have a voice in how those things are managed and prevention of pollution, things like that. So that's my thoughts, and thank you.
Thank you, Ms. Lewis. If you would spell your first and last name.
Sarah, S-A-R-A, Duke, D-U-K-E.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead.
Thank you for this opportunity. I live in Chimayo, and I'm on the Acequia de la Cañada Ancha. I've been a commissioner and now I'm a project manager to improve the infrastructure so we can maintain water for our community. We're very agriculture based. Food is life, water is life. And I've been an organic gardener for over 40 years. I am a little bit older. And I don't pollute my soil, or sure wouldn't want the water to be contaminated in any way. So I really encourage the adoption of strong, enforceable rules. Enforcement is really, really critical. That people who pollute should pay and have to clean up. And I appreciate, I hope we all know how important the water of the rivers and lakes and streams and reservoirs are, but to the Acequia system, it's people's livelihoods. And if it's not safe water, our lives can be really ruined. So I appreciate this time. Thank you.
Thank you very much. If you would spell your first and last name.
Of course, my first name is Ryan. That's R-Y-A-N. Last name Tate, T-A-T-E.
Do you swear or affirm to tell the truth?
Yes.
Go ahead.
I appreciate you all for having us today as we gather on southern and northern Tewa land to discuss the health of this earth. My name is Reverend Dr. Tate. I live in Albuquerque. I was born at Presbyterian in Albuquerque. I went to Chamiza Elementary School, Bosque for middle school, Volcano Vista for high school, and as we all present here know, everyone is a Lobo. I'm speaking today as a member of New Mexico Interfaith Power and Light, which is a group that brings together people of faith and conscience over a common cause of earth care.
Dr. Tate, I'm sorry to interrupt. Would you slow down just a little?
Period. We are collectively urging the Commission to adopt robust and clear rules to fully implement SB 21 so that our waters remain clean and clear of pollutants amidst the dissolution and gutting of needed federal protection. We are a southwestern state in the Sun Belt, and as the effects of drought and climate-related changes increase, our most marginalized communities, human and non-human, bear the brunt of that. In my spiritual tradition, we give honor and thanks to all of the spirits of the land. Water holds a special place in my heart as I am a child of the water. Water is my mother, my sister, my best friend, and she deserves all of the protections any being deserves to live a flourishing and fulfilled life. As we look at the naked Rio Grande, cracked acequias, and dry riverbeds this summer, let us remember the precarious reality our state occupies. And just as my spiritual path calls me to advocate for the spirit of the land, it also calls me to advocate for her caretakers and insist that rules that protect tribal waters to the fullest extent are enacted clearly and easily. Plainly, protect the full breadth of New Mexico's surface waters, including rivers, streams, wetlands, and smaller tributaries and drainages. Enact rules that are at least as protective as lost federal protections, rules that protect tribal waters to the fullest, and ensure robust public participation so New Mexicans have a meaningful voice in decisions affecting their water. And finally, rules that protect wildlife by requiring meaningful engagement with the New Mexico Department of Wildlife. Together, we can heal the broken tapestry of relationship with our waterways and the sacred land we occupy. Thank you for your time.
Thank you very much. Hello, if you would spell your first and last name.
Clara, C-L-A-R-A, Sims, S-I-M-S.
Do you swear or affirm to tell the truth?
I do.
Please go ahead.
Thank you to the Commission for hearing public comment each day of this hearing. My name is Clara Sims. I was born and raised in Los Lunas, and today I'm speaking on behalf of New Mexico Interfaith Power and Light, which is an organization that works with people in faith and conscience to care for our common home. Today, I urge the Commission to adopt strong, comprehensive, clear, and enforceable rules that fully implement SB 21 to protect New Mexico's waters from existing and future pollution. Establishing a strong permitting system to safeguard all our surface waters is desperately needed as climate change intensifies drought and water scarcity across our state. If we do not effectively implement the strongest protections possible, we place the future of all we love and all that sustains us at risk. In our many diverse faith traditions, we understand that water is sacred because water is life. Water is much more than a resource. Water is the lifeblood of this interrelated web of creation that we are called to know and love as kin and neighbor. As the floor of federal protections for our state waters under the Clean Water Act have collapsed beneath us, we stand at a critical crossroads. In 2024, every river in New Mexico was included on the most endangered rivers list. And from the Rio Grande to the Chama to the Gila to the Rio Hondo, we are all confronted by the haunting reality of dry riverbeds and diminished in-stream flows. Behind the reality of our endangered rivers is the reality of our endangered state, our endangered communities, and our endangered ways of life. Personally, as someone blessed to have inherited irrigated land, I fear that I will not be able to pay that gift forward to my own children if we do not create strong and enforceable regulatory frameworks to protect the health and integrity of all our surface waters. But it's not too late to change course, and today I urge the Commission to adopt rules that protect the full breadth of New Mexico's surface waters, rules that are at least as protective as federal loss protections, rules that protect tribal waters to the fullest extent possible, rules that ensure robust public participation for every New Mexican, and finally, rules that protect wildlife by requiring meaningful engagement with experts at the New Mexico Department of Wildlife. The choices made in this room can create a geography of hope for our waterways, and therefore for all of us who love and cherish this place we call home. On behalf of our collective future in this place, please pass the strongest rules possible. Thank you.
Thank you very much. Is there anyone else here to offer public comment? Please come up. Would spell your first and last name.
Hi everyone, my name is Carolina Carrillo.
Okay, spell it.
Caroline. Carrillo, Carrillo.
Okay, do you swear or affirm to tell the truth?
I do.
Thank you. Speak up a little bit.
Okay, thank you. Hi, members of the committee. My name is Carolina Carrillo, and I'm here to ask you for support. As a New Mexico resident, I live in Belen, New Mexico, and I have 5 children. We really enjoy to go out to the recreation, to the river. And as a mom, it's so important to me that my kids have this opportunity for generations. I want to see, if God let me, my grandchildren enjoy the same water or the same things we've been part of it. For me, it's very important to protect the water. We struggle a lot on Belen because of the water. The river is drawn now, and I live in a fair because I'm a single mom. My neighbor's water is always gone, and I'm so afraid to face that with my kids, and need to pay a lot of more money to invest and dig a hole and grab more water, and it's that's why I'm here today, because I'm so worried about the future generations. I'm so worried about my kids' future, and for me, I believe that it's time to do something today and ensure that we have a better future for our kiddos in New Mexico. Thank you for your time.
Thank you, Ms. Correa. Is that another hand over here? There's a hand. Who would spell your first and last name, please?
My first name is Monica,
Monica. My last name is Ibarra, Ibarra.
Do you swear or affirm to tell the truth?
I do.
Please go ahead.
Good afternoon, members of the commission. I recently moved from Hobbs to Berlin, New Mexico. I appreciate the opportunity to speak today. I grew up understanding how important water is for every person in New Mexico. I am here today because water is personal to me. Like many people in New Mexico, I acknowledge how precious water is. We live in a state where every drop matters. Our streams, our rivers, our wetlands are not just parts of the landscape. They support our communities and our traditions, our food systems, and our wildlife that makes New Mexico unique. In Hobbs, many people do not feel comfortable drinking the water. It often has a strong chlorine smell, leaves mineral buildup in our homes, and many families spend a lot of water on bottled water because they do not trust the water that's coming from the tap. Some residents have even received notices warning about contaminants and potential health risks. That experience taught me something important. We should not wait until water quality becomes a problem before taking action. Clean water protects our health, our communities, our economy, and our future. That is why I support strong protections for all of New Mexico's surface waters, including streams, wetlands, and rivers. We need rules that prevent pollution before it happens, protect communities downstream, and ensure future generations have access to clean and safe water. All New Mexicans deserve clean, safe, and reliable water. I urge the Commission to adopt strong and comprehensive, clear, and enforceable rules that protect New Mexico's waters from existing and future pollution. Thank you for your time and your consideration.
Thank you very much, Ms. Martin. Other commenters, please come on up. If you would spell your first and last name.
Yes, ma'am. My name is Blanca Bella. Blanca, B-L-A-N-C-A, Bella, B-E-L-A.
Would you lean forward toward the microphone a little bit? Yeah. Do you swear or affirm to tell the truth?
It's true.
Go ahead.
Good afternoon. My name is Blanca Bella and I live in Albuquerque. I am a single mother and I'm here today because I care deeply about New Mexico's future and the water that supports all of us. For most of my life, I have understood that water is our most valuable resource. And as I have gotten older, I have come to understand how true that is. Water supports our families, farms, economy, wildlife, and the place we love. When my daughters were young, I often took them to the Rio Grande. We spent time exploring, playing, and enjoying nature together. Some of my favorite memories as a mother come from those days. The Rio Grande was more than a river. It was a place where we learned, connected, and made lasting memories. And don't get me wrong, I'm not talking about swimming across it, but it was a place of connection, learning, and joy. It's part of our history, the history of this country. This is why I support strong protection for all New Mexicans' surface waters, including smaller stream wetlands and seasonal waterways. That's what this water help keep our water clean, support wildlife, and strengthen larger watering systems. I believe we should do everything we can do avoid harming our waters in the first place. any projects involving our water. So look for less alternatives. And when impact cannot be avoided, strong mitigation measures shall be required. This community deserves a voice. Its decisions that affect the water and tribal waters. Quality standards should be respected and protected. Clean water is not a political issue. It is something every family depends on, and I urge you to adopt strong rules that protect our water and ensure future generations can enjoy them for years to come. Thank you for your time and your consideration.
Thank you, Ms. Bella. Other commenters in the room? We also have a number of them on the platform. All right. On the platform, then Dana Loy. Can you unmute yourself? Dana Loy. Can you unmute yourself? Dana Loy. All right. Adrian Angelo. Can you unmute yourself?
Yes. Hola, buenas tardes. My name is Adrian Angulo, Adrian, Adrian Angulo, Angulo.
Thank you. Do you swear or affirm to tell the truth?
I do.
Go ahead.
New Mexico is the only home I've known, and I really appreciate the commissioners for this opportunity to speak. I work at the Nuestra Tierra Conservation Project. I'm also an irrigator and raise goats in the Middle Rio Grande Conservation District in the South Valley here in Albuquerque. More importantly, I am a proud dad. In just my 5-year-old daughter's lifetime, though, we've gone from about 8 to 10 irrigation days to just 2 this year, much to the goats' chagrin. Any opportunity to sneak in chagrin is a welcome one. Water quantity is a serious issue, and I deeply appreciate the collective hard work to meet this problem head on. The need for action is urgent. We have an obligation to set strong and clear rules here during these hearings, ensuring that we have an avoidance first rule so that applicants and companies must show that they're prioritizing the least harmful option first is essential. I think there's a lot of opportunity for cross-department coordination between NMED and the New Mexico Department of Wildlife to make sure that we're aligned between our use of water and its very real impact to wildlife, fish, and habitat. Not to remake a point again, but to continue feeding a fed horse. New Mexico simply can't afford weak protections to jeopardize our already limited water resources. Thank you to the commission again and everybody here. I urge our commission to adopt strong, clear, enforceable rules that fully implement the good work that went into SB 21. Thanks so much.
Thank you, Mr. Angulo. Ruth Striegel. Can you unmute yourself? Ruth Striegel. I've stepped away. Paul Tashian.
Hi, this is Paul Tashjian. It's Paultashjian.
Do you swear or affirm to tell the truth?
I do.
Great, go ahead.
Okay, yeah, I'm a hydrologist in New Mexico. I worked for the Fish and Wildlife Service for 27 years with the wildlife refuges and water issues. I've lived in New Mexico for 37 years, and I love the state like everybody else. Here, I'm an avid fisherman, canoer, outdoorsman, and lover of wetlands and water courses. I'm very pleased that New Mexico is establishing a surface water permitting program, and I'm very excited that they're developing this rule set to clarify process. I'm encouraging the rules to ensure that there is coordination between the Environment Department and the New Mexico Department of Wildlife over at-risk species when issuing water quality permits. At-risk species include species that are experiencing population declines and include state and federally listed species, as well as ones that are in jeopardy of becoming listed. Our wetlands and rivers are in crisis, as can be seen by the extent of river drying on the Rio Grande today. We have very few intact wetlands in the state, and these hold incredible importance for at-risk species, disproportionate importance in terms of the landscape. I'm urging that the rules recognize the importance of at-risk species in the water quality permitting process by establishing clear protocols for coordination between the Environment Department and the Department of Wildlife when permitting wetlands with identified species, and that additional protection is put in place through this process for wildlife when at-risk species are associated with the permit. Thank you so much.
Thank you. Bria Merrill.
Hello, thank you. I am Brianna Merrill, B-R-I-A-N-N-A, Merrill, M-E-R-R-I-L-L. And
Thank you.
I'm
Do
here
you swear or
speaking.
affirm to tell the truth?
Yes, I swear.
Okay, go ahead.
Thank you, commissioners and public, for your lovely comments so far. I am here speaking on behalf of the Pueblo of Isleta. The tribes, pueblos, and nations have depended on and cared for the waters within what is now known as the state of New Mexico since time immemorial. Ensuring good water quality upstream of the Pueblo of Isleta is just as important to tribal members as it is to the public at large. We all
Ms. Merrill,
depend upon.
sorry, slow down just a little bit.
Okay. We all depend upon these waters for household, agricultural, municipal, industrial, and recreation uses that support everyday life. However, for tribes, meaningful water quality standards are especially critical for our cultural practices. Our cultural traditions that have been carried forward by generations of tribal members throughout thousands of years necessitates clean and safe water. If the water quality is such that our people experience adverse health effects from primary contact with the sacred river water in ceremonies, then we as humans are failing our stewardship responsibilities to our human, plant, and animal communities. Indigenous peoples are the first water managers of the Rio Grande. The state should not create additional hurdles for tribes to protect vital water resources. Senate Bill 21, the framing legislation for the rules the WQCC has before you today, 20.6.2 and 20.6.5, includes clear and broad protections for downstream tribes' water quality standards. We understand that neither the Water Quality Act nor the New Mexico Pollutant Discharge Elimination System Act provide a definition on tribal water quality standards, and so understand the need for this body to define that term in regulation. The Pueblo of Isleta supports the definition proposed by the Environment Department in Exhibit 79. Tribal water quality standards means standards established by the governing body pursuant to Indian Nation, tribal, or Pueblo law, and ask that the Commission reject the additions to this definition proposed by other parties that would require tribes, pueblos, and nations to obtain treatment as state designation out of respect for tribal sovereignty. The definition of tribal water quality standards in Exhibit 79 recognizes that tribes are the best stewards of our sacred water resources. Placing additional burdens on tribes who have water quality standards disregards tribal sovereignty and distances tribal leaders from decision-making processes affecting our shared resources. The Pueblo of Isleta does have treatment as state designation in relation to the Clean Water Act 303 and 401, and accepted water quality standards that the Pueblo of Isleta as a sovereign nation has adopted into our scope of governance. It is the Pueblo of Isleta's hope that our sovereignty and shared goal of high-quality water resources will always be respected by industry, local, and state entities without the need to utilize TAS status to obtain federal enforcement of the standards that have been democratically adopted by the Pueblos. Beyond Isleta Pueblo, we are concerned that this requirement would be limiting for tribes across the state. In addition to how the requirement may be applied, the state program in the future for tribes who no longer have federal jurisdiction over their waters within their boundaries. Furthermore, tribal members live both within and without the exterior boundaries of the Pueblo of Isleta. And for those tribal members residing in other communities, they deserve water quality standards such that those individuals and families may hold ceremony for themselves where sacred waters are most accessible to them. For these reasons, the Pueblo of Isleta urges the Commission to adopt the definition of tribal water quality standards included in Exhibit 79, standards established by the governing body pursuant to Indian Nation, tribal, or Pueblo law. We encourage the Commission to reject any alternative definition that would limit the intended broad protections for tribes and our water quality put forward by other parties. Thank you again to the Commission for your work and your time, and thank you to the public for your great comments.
Thank you, Ms. Merrill. Margaret Bell.
Am I unmuted?
Yes, you are. Please spell your first and last name.
Margaret, Margaretbell.
Do you swear or affirm to tell the truth?
Yes, I do.
Please go ahead.
Chair, members of the Commission, thank you for the opportunity to give comment on the rulemaking today. I live in Albuquerque. The dogs and I walk through the open space to the west of the Rio Grande Nature Center in Albuquerque to the Rio Grande River. It is heartbreaking that all we see now is dry riverbed. In 2022 and 2025, it dried out in July. This year it happened in May, and it's still dry, with no end in sight. And it's not just the Rio Grande. Every river in New Mexico was included on the 2024 Most Endangered Rivers list. I am grateful to our state legislature for passing SB 21 to protect our precious surface waters in this environmentally hostile federal environment. It is now up to this commission to issue strong, comprehensive, clear, and enforceable rules that fully implement Senate Bill 21 to fully protect New Mexico's waters from existing and future pollution. Weak rules would leave vulnerable waters, communities, and future generations at risk for years to come, threatening the viability of New Mexico's future. I urge the Commission to adopt rules that protect the full breadth of New Mexico's surface waters, rivers, streams, wetlands, and the smaller tributaries and drainages that sustain them. Be at least as protective as lost federal protections, including incorporating the 404B1 guidelines to ensure that impacts are avoided, minimized, and compensated for. Protect tribal waters to the fullest extent possible. Ensure robust public participation so New Mexicans have a meaningful voice in decisions affecting their water. Protect wildlife by requiring meaningful engagement with the New Mexico Department of Wildlife, and protect New Mexico's water by issuing industrial-scale concentrated animal feeding operations, known as CAFO, specific rules that ensure that all discharging CAFOs are covered by permits, and impose strong pollution control requirements on these polluting operations. If our limited and precious surface waters are not protected, there is no future for New Mexico. I strongly urge the Commission to act accordingly and pass strong, clean water protections that ensure a healthy and safe future for all New Mexico inhabitants. Thank you.
Thank you, Ms. Bell. Peggy Nelson. Peggy Nelson. Peggy Nelson, can you unmute yourself? All right, let me go back to Dana Loy. Are you able to unmute yourself? Or Ruth Striegel, are you able to unmute yourself? No? Is there anyone else on the platform? Oh, I see a hand at the top, Pam. Is it Soledad Garcia?
Yes.
Hello, you need to unmute yourself.
Good morning, or good afternoon.
Yes, hello. Would you spell your first and last name, please?
Yes, my name is Soledad Garcia, Garcia.
Thank you. Do you swear or affirm to tell the truth?
Yes, I do.
Go ahead.
I am a lifelong resident of New Mexico from the community of El Huache, which is in Rio Ribe County. I am a parciante of the acequia de Los Salazares. I'm also a commissioner with the New Mexico Acequia Commission, and I'm here today to affirm Senate Bill 21 and ask that this commission, in many ways, affirm its full implementation to protect the waters of New Mexico. I come today because in New Mexico there's over 700 acequias in local communities. Oftentimes these are the lifeblood of these particular communities that serve to be the base institution for their culture, for their livelihoods. And I come today also in many ways to ask that that we reflect on the sanctity of water and how it, in many ways, forms a sacred bond in which we have in terms of creating relationships that either, in many ways, in a lot of the Acequia communities, to deny someone water was to, in many ways, relegate a person to would be death. And so, in terms of that, thinking about water is a very political issue, but oftentimes, in many ways, we turn to having a sense of a politics that is based upon necropolitics, in which only some people that are privileged can have clean water that is not damaged by environmental contamination. And so I asked this commission to, as I said, use SB 21 and to its full extent. That is it. Thank you so much for your time.
Thank you, Dr. Garcia. Last call for public comments during this session. Our next session is 1 o'clock tomorrow. And then there'll be another one, 1 o'clock Friday. No hands, Pam? Peggy Nelson.
Peggy, can you unmute yourself?
I believe, can you hear me?
Yes, now. Yes, we can.
Oh, thank you. Thank you. I was having a very difficult time unmuting myself. So Peggy Nelson, PEGGYNELSON.
Do you swear or affirm to tell the truth?
I do.
Okay, go ahead.
Thank you all for this opportunity. I really appreciate the fact that you are taking so seriously this critical issue. I do want to say first, though, something about myself. I'm not a native New Mexican. I have been here in New Mexico for 53 years and have spent my entire I should say professional life in northern New Mexico. I live in San Cristobal, which is a small community in Taos County, dependent on a very small but beautiful watershed. We all know how precious water is for life in all its forms. I have been a parciante, ditch commissioner, and am a user of a domestic water system whose source of water, in fact, is San Cristobal Creek. As a child, I was raised with firsthand knowledge of the water wars between the Los Angeles Water and Power Department and the ranchers and residents of the Owens Valley, the first place from which water was taken or stolen to allow for the amazing growth of the Los Angeles basin. There I learned about issues of water quantity. In New Mexico, I have learned not only about quantity, but also quality. I have been on the board of Amigos Bravos for a number of years and have worked on these issues. The Sackett decision was devastating when it stripped clean water protections. The hard facts began to emerge. New Mexico was hit very hard by this change. Up to 95% of New Mexico's streams and up to 88% of its wetlands lost protections that had been in place for half a century. All of New Mexico's wetlands, intermediate, and ephemeral streams are important and critical in this arid climate, and they deserve our protection. When SB 21 was passed, we had the opportunity, and now have it before us, to create our own surface water permitting program. We not only need, but urge the state to adopt strong and very enforceable rules for the implementation of SB 21 that sets specific standards and requirements for controlling the release of pollutants into our rivers, lakes, streams, and wetlands. This is especially dire as drought has gripped the state and climate change is driving aridification. Federal protections that are now lost provided only the floor for what protections were needed before Sackett. New Mexico can do more and provide even more protection, and this is that opportunity. The requirements under New Mexico's new rules must be at least as protective and should be something that sets the standard for all other states that do not have state permitting programs. The rulemaking process you undertake is critically important and needs to have a variety of things, including the following: protections for all of New Mexico's surface waters. Any dredge and fill project proposal must demonstrate a real attempt to avoid damage or destruction to any wetland or waterway before mitigation is even considered. The rule should establish a 2-to-1 mitigation ratio so that if a wetland is destroyed, twice as much is created or remediated. This would help prevent a wetland loss of both acreage and function for the environment. Many others before me today have demanded engagement with the Department of Wildlife, and I would do the same. Wildlife should play a meaningful advisory role in surface water permitting. Public participation is also critical on general permits and must be robust and meaningful. Any New Mexican affected by a proposed permit has to have a voice in the process. Ms. Merrill spoke very eloquently about tribal water protections, and I just would urge you to remember her comments, and I will skip over that. She has far more knowledge about that than I do. Any rules should adopt language that makes tribal consultation and public consultation a requirement. There also needs to be a streamlined permit process for restoration projects. When groups restore or repair damaged wetlands and streams, it's not the same as polluting entities needing to clean up their mess. Working to restore a watershed should begin as quickly as possible under any new rules. And I also want to thank those who have come before me. I'm rather prosaic here, but there have been some very, very heartfelt, wonderful comments, and I thank everybody who has gone before me. What I really would like to urge and have you consider is that I really believe this is the opportunity of a lifetime. And the rules that emerge from this lengthy process should reflect the best that New Mexico has to offer its citizens, wildlife, and wetlands. And we all deserve clean water. So thank you very much for your attention.
Thank you, Ms. Nelson. All right, last call for Ruth Striegel.
Hear me this time?
Oh, yes. Spell your first
Okay.
and last name, please.
Ruth, R-U-T-H, Striegel, S-T-R-I-E-G-E-L.
Do you swear or affirm to tell the truth?
I do.
Please go ahead.
Thank you. My name is Ruth Striegel. I reside in Albuquerque, but I live thanks to the waters of the Rio Grande and the aquifer that sustains it. I volunteer as the chair of the board of directors of New Mexico Interfaith Power and Light. Every day we see the impacts of climate change and human activity on our environment and on specific species that are under threat. As a person of faith, I am called to speak up for the other than human world and the myriad life forms that depend on clean water but do not have a voice in these deliberations. The health of the web of life is not optional. Our survival depends upon it. I urge the Commission to fully implement SB 21 by adopting comprehensive, enforceable rules to robustly protect New Mexico waters of all kinds. We live in a desert and we are experiencing generational drought that threatens our environment and our water supply. SB 21 gives us a huge opportunity to do it right and ensure we protect our waters for generations yet to come. Specifically, I urge you not to narrow the scope of the program or limit which state waters are protected. Further, do not change the current strong definition of tribal water quality standards. Our Native communities live very closely with the land and deserve the waters that they have stewarded for generations. I also ask that you add requirements to consult with the State Department of Wildlife to eliminate discharges that will impact sensitive species. Thank you for the opportunity to speak.
Thank you, Ms. Striegel. Last call for Dana Loy. Dana Loy, can you unmute yourself? Who's up at the top? Hello? No? All right. We're going to call this public comment session to an end then and return to the technical case. The next opportunity to offer public comment is 1 p.m. tomorrow, and again 1 p.m. at Friday. We're going to go back to the cross-examination of the department panel. Would resume your seats there, and Ms. Richards, you are next. You join us on the dais. We have everyone in place. I think we do. We're losing one. All righty, Ms. Richards. It's 2 p.m.
How about now? Thank you. Good afternoon, members of the commission and our panel. Thank you for coming back after lunch and not being hangry. I'm confused about some things that have been talked about in cross-exam, probably because I'm just confused. So I'm going to ask first Mr. Connolly some questions of you. So it seems to me you've done kind of your fee assessment and the whole fee schedule. And I'm wondering just a couple of general things. Can you tell me what the average NIPD's style permit, I'm just going to keep calling it NIPD's, I know it's going to be a state permit, but the average New Mexico point discharge permit would be for the average permittee?
Approximately 500 hours would be the assumption.
Hours or dollars?
Hours to generate. So, well, my spreadsheet. Approximately 32,000.
And what is the what's the high fee?
The high fee?
Right, the highest fee that a potential permittee would have to pay.
Oh, in terms of annual?
Yes.
Or, There are different fee structures for a POTW and industrial, but for the highest, the absolute highest in the entire program would be 293,125 and annual of 91,000.
So the application would be 293,125 and then yearly another 91,000?
Yep.
Do you know which entity would bear that cost?
I do. That is Los Alamos National Laboratory, which has 450 outfall.
Okay. And is that and that's for the kind of primacy federal NIPDES permit versus the state surface permit? Because I understand there's basically a bifurcated regime that will be happening.
Yeah, they'll be the same cost essentially. We don't want to create a situation where you have different costs and people shop around for different, which water is cheapest to pollutant.
So is there a potential where the New Mexico PDES gets issued, you pay this about $400,000 a year or so for the first one. And then you also have to have a separate state permit for the waters that are not included in the CWA primacy portion. Could there potentially be two permitting regimes?
If so, then this cost would change. I mean, this is based on all outfalls and considerations of the facility, but it wouldn't be unusual, and this might be a case where you can actually do a state and federal. We haven't talked about this, but I know I've worked in states that they have, where you'll have state requirements and federal requirements under a single permit. You don't have multiple permits for the same facility.
So Ms. Lemon, to follow up on that with you, so trying to figure out, so you're going to apply to EPA for primacy under the Clean Water Act covered systems, and then you will have your own state surface water system. Is the intent to, at times, have two permits or to cover those extra waters that are not included in the Clean Water Act type program that you received primacy for?
No, that is not the intent. Like Mr. Connolly said, if there are waters that are not covered under the federal program, it would still be looped into one permit for that entity. Again, that depends for Los Alamos National Lab. There's 450 outfalls that are currently covered in multiple drainages, and I think 7 different sub watersheds. I mean, it's a lot, and it's considered federal right now. That would maintain it when it comes to the state as one permit for that whole structure, what is in existence now, unless the cleanup happens and no discharges are happening anymore or something changes as far as that's concerned, but we would treat it as one.
And so let me ask this for some clarity. So would that comprehensive permit have both like a state primacy portion and then a state portion? Because it's different based on enforcement, right? Because only federal enforcement is authorized under Clean Water Act derived programs. So I would understand that you'd have to have separate enforcement strategies. And how would they be broken out in a permit?
That's a good question, and a conversation with EPA as we move towards primacy and how to deal with the most complicated permit that we have, which I believe is that permit. So that is something that could be detailed. We do detail waters and sub watersheds in the permit right now. So that is something that could be detailed in the permit.
And like talking about some of the other permit types, multi-sector general permits, Mr. Connolly, are those are something the state would also be implementing, is that correct? Have you looked at fees for that?
Yep.
And can you tell me what the fees would be looking at for an MSGP type permit? And while you're doing that, I'm gonna grab my water.
Oh. Yeah, $550 as an application fee, $800 as the annual.
And how about, have you done any fee structuring for MS4 permits?
We do have, the attempt is to cover the MS4s in a general permit, and the application fee there is $2,500 and an annual fee of $3,000.
So if you're addressing MS4 and the MSGP, would there be one comprehensive permit then instead of two? No.
No.
So two separate permits for that. So potentially one large permit for covering state surface water PDES and federal NPDES, and then another MSGP and then another MS4, and you're paying for all those things separately. I broke my promise to you to look at your hand.
For those, that's what I would envision. You can correct me if you look at something, if you're looking at something else, Shelley, but the whole intent of general permits is they're low cost because you are grouping so many people under a single one. And if you have to start individualizing it, you're losing that benefit of a general.
So for those general permits that you mentioned, the MS4, it's for urban stormwater. The MSGP is for industrial stormwater. So they're different types of stormwater permits. Are you asking if like Los Alamos National Lab would have to get a state issued MSGP and a NMIPD's issued MSGP?
Yes.
No.
Okay. So let me ask both of you, whoever can help with this the best. Sandia National Labs currently has an MSGP and an MS4. I'm wondering what type of permitting Sandia would be getting after this rulemaking is implemented.
They currently have an MSGP and an MS4?
Yes.
Under the federal program?
Correct.
That would be under, I'm assuming, the NMIPD's program. So that would follow the primacy pathway that I've talked about and the phasing in of that program after EPA's approval for authorization.
And then right now, there isn't a third styled permit such as the surface waters. Do you envision potentially Sandia National Labs needing to have that additional state surface water point source discharge permit, the new NMEDES? We got to figure out a shorter name for that.
NMIPD's.
NMIPD's, okay.
For individual permit?
For operation of the facility, the lab.
Is there a discharge to a surface water? I mean, if the lab is already covered under the MSGP and MS4, is that what you said?
Yes.
I'm trying to remember. Those would be the permits that I think would be required unless something changes.
Okay. Mr. Connolly, earlier you talked about that the fees are based on, I quote, high risk facility, and they would contribute a proportionally larger share of the fees to operate this program. Do you recall that?
If I said high risk, complex, essentially more time consuming permits, the larger facilities also are presumably more high risk, as if they're discharging larger volumes. They can proportionally impact the receiving water.
Okay, so thank you for clarifying that. When you were talking about high risk earlier, you talked about two aspects of that: higher regulation and higher environmental risk. I'm going to ask some questions about that as I break this down a little bit more. But is the higher proportionally contributing fee on a sliding scale or a flat schedule?
When you say sliding the flat, and
Sure, I'm just trying to understand, you know, if
I'm sorry.
No, go ahead.
Are we talking about an industrial, or are we talking about POTW? Because they both have different.
Let's talk about industrial first.
Industrials are going to be based on the things that get considered in determining an industrial are going to be whether it is a major or minor, and generally major just because they are typically larger or more complex, higher risk. They do have a slightly higher base fee. The number of outfalls associated with that industrial facility, that is additional labor, level of effort with generating a permit, compliance oversight and such. Complexity associated with it, the industrial facility, there's a wide range of industrial facilities that can be covered, and some are significantly harder to write NPDES permits for than others. Those are those are essentially the consideration.
So the fee, it seems like it's not really knowable until you submit an application. Is that fairly accurate?
If you know if you are a major or minor, if you know how many outfalls you have, if you look at the regs to determine your complexity factor, you should be able to know what your fees are going to be.
And when you say major or minor, what do you mean by major or minor? Size? I'm just not sure what those terms are meaning.
There's within the MPDS permit world, there is a designation. There's a form that's filled out, and it talks about your proximity to certain sensitive water bodies, volume of discharge, types of pollutants you discharge. That can classify you as a major or a minor. If you currently have a permit and you're a major, you're likely going to be a major again, similarly with a minor.
Is it like major facility, major contributor, major discharger, or is it just major minor?
It's major within the MPDS world. There's just majors. It's a classification of permits that require higher regulatory oversight.
Thank you. And then in the breakdown, your earlier testimony talked about low risk and high risk. Is there, I guess, a medium risk population in the putative permittee world?
I mean, minors would be, you're either high risk or you're not, more or less.
Now, you said high risk was based on a combination of the higher regulatory demand and the higher environmental risk. What is the higher regulatory demand based on like the number of outfalls, the size, the type of activity? Is there other factors I'm not thinking of?
All of that.
And then does it result with a high regulatory status as you're working through the fees and the complexity? So that would be like a designation on, I don't know, an application or whatever document is issued after.
No, it's not a classification. When we're saying high risk, that's not a classification, and that's not I didn't intend to classify that facility's high risk. It's just the way the fees work out. Typically, the facilities that are higher risk are going to have higher fees.
And then you were talking about higher environmental risk. Can you tell me, I'm struggling with understanding where the environmental risk designation is coming from. Is it based on, for example, risk to water or risk to other environmental factors?
Both of those can be considered on the major or minor worksheet. Proximity to sensitive water bodies, the types of pollutants that are discharged. I don't recall the entire worksheet off the top of my head, but it has a number of factors.
Do you know of any of environmental factors that are not directly tied to water quality that are considered? For example, proximity to a Superfund site. For example, proximity to a Superfund site?
I don't believe that makes them a major proximity to us.
Is there factors such as the size of the population nearby? Is that one criteria?
Not the size of the population, the size of the discharge may be considered. And is more so with POTW.
Ms. Lemon, are you aware of any other, I guess, when we're looking at the environmental risk factors that are not directly tied to water quality itself?
I think it's, there are certain factors such as like drinking water intakes, proximity to drinking water intakes, which is considered water quality, but not water quality because it's used for drinking water. Possibly proximity to threatened and endangered species, sensitive species and their habitat. Again, that's within the discharge zone if they use the aquatic habitat for their life cycle, things like that.
And are these higher environmental risk type factors identified somewhere in the regulation?
The major or minor designation, and it would be when you determine a facility is major, you are supposed to fill out the major minor worksheet and document it in the permit file.
But in this rulemaking, in this particular rule, it doesn't go into the different factors that should be considered that be separate in the application process?
No, it's the only thing considered that would be high risk is major minor.
We do have criteria requirements for applications that include some of those things, like providing information on some of those aspects. Yes.
So some of those aspects, but not all of those aspects.
I don't know if we covered all of the aspects, so I'm qualifying that.
Is there someone else who would know if you covered all the environmental factors that would need to be outlined in the application?
We put in here what is required for the application. Yes.
Okay, I apologize. I'm just trying to get some clarity. You said that some of the aspects are included and some aren't. And I didn't know if perhaps there was another witness who knew more about those factors or they're just not in there.
I'm not sure you're talking about environmental factors that would classify you as high risk, but high risk is not a classification that we have. We have major or minors. I use high risk locally. That might be something that makes you a major, more or less, but it's not a classification under the NPDES permits and permit program that we're working.
Okay, then substituting out from the prior testimony of high risk versus major, does this rulemaking identify the environmental factors that will be considered in determining that you're major, which will then flow into your fee category?
The application requirements are consistent with what we will use to make that determination. Yes.
And then the intent is by the department to not add additional factors that are not reflected in the rulemaking already.
Again, the application requirements are listed. We may have questions when the applicant submits their application. There may be incomplete things that are submitted that we need to follow up on, but there are requirements that are listed in the rules.
And we would likely use, and this would be part of implementation to carry out the regs, the major minor worksheet provided by you, but that is to be figured out.
Okay. So let me ask a question about ABC WUA, or Albuquerque Bernalillo Water Utility Authority. They were talking yesterday, had some cross-exam questions. I think I recall that their fees would be around 200,000 or so. Is that about right?
Yep, that 177,242.
Right. And then you understand that those fees would be flowed down to the consumers. Is that correct?
We most likely, yes.
I think you also said that there'd be 7 facilities who will receive new permit charges of higher than $100,000 per year. Can you tell us which those 7 facilities are?
Sure. Farmington, Roswell, Clovis, Rio Rancho, Santa Fe, Paso Real, Los Cruces, Jacobs Hands, and Albuquerque. I'm sorry. For the other one we were just
ABC WUA, yeah. So, and for what type of permit is that?
Those would be major publicly owned treatment work.
BOTW.
BOTW, yeah.
Did you do the same type of analysis for the industrial?
No, these are based purely, well, there are major and minor considerations, but these are based purely on flow of the facility.
Okay.
And it is everybody, as you discharge more, your fee increases proportionally with that. Everybody pays the same for the first 10,000 gallons they can discharge. Everybody pays the same for the next 15,000 gallons they can discharge, and so on and so forth. When you get up to 67 or 76 million gallons.
Did you do any type of an assessment to, I guess, come up with how many other types of facilities, industrial facilities like Landell or Sandia National Labs, would be paying more than $100,000 in permit charges per year?
I believe it's 7 in each category.
Okay. And in that category, which facilities are those? And I won't ask you their amounts.
Oh, well, these are going to be annual, or not. These are going to be the application fees. The annual fees are all below 100K. Okay. Chevron Mining, Westmore San Juan Mining, Peabody Natural Resource, which is also a mine. Chevron Mining, a separate mine. Los Alamos, as we spoke about, and Lee Ranch Coal Company. All of these with significant number of outfalls: 23, 32, 35, 67, 450, 53.
Thank you. Now, in your testimony before, you also talked about the complexity factors. Are those the same types of factors that go into the major minor determination?
No, they do not go into the major or minor, although they may overlap. One of the aspects of major or minor might be if you are, I'd have to look at the worksheet, but it might be if you're subjected to effluent limitation guidelines. But the complexity factor is essentially, if power plants, for example, they have 316A, 316B requirements associated with them, which make them incredibly expensive and difficult. There are multiple additional studies that you have to look at when you are permitting a power plant. Mines are subject to ELGs. They are more difficult to write than a typical NPDES permit, so they have a complexity factor of 1.25. Los Alamos has a designated complexity factor of 2.5, where there are 450 outfalls in the various water bodies and such.
So the complexity factor is directly tied to how hard it's going to be to drop that permit.
Yep.
All right. So would you mind telling me just kind of listing out a little bit more of those factors so that I have a better understanding? Besides the outfall number, what other types of items?
Sure. All the things that go into generating the permit fee for industrials are number of outfalls, major or minor, the complexity factor, and that is it.
And then under the complexity factor, it's just size, or?
We have it in the rule. It's the level of effort, the permit complexity, the type of facility, possibly the volume of wastewater, because not all of the dischargers discharge continuously, application of effluent limitation guidelines.
Do you have that section of the rule open?
It's in the fees section. It is 2351A to A3.
Okay. Mr. Connolly, do you know if the Environmental Protection Agency currently charges for permit applications?
I'm sorry, could you repeat the question?
Sure. Do you know whether the EPA currently charges for permit applications?
I know they do not charge permit.
And is that because it's federally funded?
Yes.
I'm a little puzzled about the discussion of EPA backlog by different regional offices, and there was a mistake between Arkansas and Arizona. I'm confused because it seems to me if it's not based on fee, then their percentage of backlog is completely untethered to fee, which is part of your argument about your fee structure and why it has to be higher. So I'm just, was that a comparison of apples and oranges?
I don't agree that the fully funding of a program is not related to backlog.
Can I follow up on that?
Sure.
So we're the 48th state to seek primacy. Those other regions, they are state-run programs. It's not EPA-run programs.
Oh, that is very helpful. Thank you.
Yeah.
So really the backlog was talking about the states being behind within those regions, not EPA itself.
Yes, ma'am. EPA does have their own backlogs, by the way, but and that is funding and staff capacity as well. I work with a ton of EPA permit writers, and they have a lot of work.
That just helped me like scratch off 4 questions.
Yeah.
Oh, I said that just helped me scratch off 4 questions for Mr. Connolly. Okay, now you also stated that if fees charged are not high enough, the program is underfunded. Do you recall that?
Yes.
And there's no other way to pay for the program.
That is not true. There are multiple other ways. Federal funds like the Clean Water Act 106 funds can support a program. They are already provided to New Mexico, and they are already designated to other programs, so they are not available for the NMD's program. And you can also have state allocations that can help fund the program and reduce the fees.
Exactly, and that was the questions I was going to ask. I think the testimony yesterday was, if it's underfunded, there's no way to pay for the program, but the state legislature could pay for some of it.
I would consider that funding the program.
Ms. Richards, we need a break sometime for the next 5 minutes. I have a good point.
I'm almost at a good point. I have 2 or 3 questions, and I'm going to switch over.
Great.
If the state were to provide some funding, or there was other, I guess, pots of money, how would that impact the fee schedule that has been currently developed?
For example, if they, and gently correct me if I'm wrong, but if they provided, say, 50% of the funding, fees would be reduced by half.
And with regard to the fee cost and how people are going to learn about this, do I understand correctly that there would be an interpretive memo or guidance memo that would outline how that all works?
How fees work?
Right, so somebody could figure out in advance, oh, this is probably what I'm going to need to pay.
I believe there would be guidance associated with how to calculate the fees and potentially even a calculator. I mean, we could put together a calculator on an Excel sheet very, very quickly and make that available.
And then with regard to that type of interpretive memo that would basically help interpret the regulation that gets implemented, I believe, Ms. Lemon, you said yesterday that generally this commission would not have a second opportunity to review and approve that. Is that correct?
To review the memo?
No, to review the interpretation or to ensure that it aligns with rulemaking, such as that.
I don't know if I said that. I mean, we report to the commission, so I'm sure that if we develop something, we could talk to the commission about it to make sure we're interpreting. Usually there is some deference for the regulating agency, but again, if the commission wants us to do that, we will do that.
And generally, when the department is interpreting rules and adding additional criteria, if the commission doesn't have some continuing jurisdiction, which is generally built in by the rule itself, would the commission normally get to have a hearing on that, take public comment, and I guess influence the department's guidance?
I don't know if we're adding criteria, so I'm not sure if that's something that I agree with. We're looking at the rule, we're participating in the hearing, and we're providing guidance on how we actually are implementing and putting it into motion. So sometimes there are guidance documents, like I said, that come before the commission. Sometimes it's internal standard operating procedures that we use, but when I go to the legislature and I'm asking for funding, they're probably going to be asking for, how are you doing this? So it's not something that is a black box. We communicate with the regulated community, with the commission, with the legislature, and with the public about things that we are working on.
I understand there's communication. I think communication is different than oversight. and having an impact. And so I guess what I'm trying to clarify is, absent some type of language in the rulemaking, this commission wouldn't rehear changes to the fee structure or changes to the guidance that might implicate how those fees are charged. Is that fairly accurate?
No, I think they could ask any time for the department to come give an update or provide feedback or adjust our guidance anytime they wish.
But again, absent that built into the rule, you don't have to go back to the commission, do you?
If they request us to come do that, we also provide the opportunity. I'm before the commission a lot. We provide them updates with things that we think they would be interested in hearing on. So it may not be defined by rule, but it is something that happens.
But the commission could not direct you to make a change. They don't have that control over the department's operation based on the discretion you have, correct?
They have control over the regulations.
But not your implementation of the regulation. Isn't that correct?
I guess that's right. But again, there are processes in place to review and revise and change the rule if it's demonstrated that it's needed in the future. So any party can petition the commission for a rulemaking hearing. It's not just the department that has control over that. So I'm not sure that what you're saying is the way it plays out in reality.
Okay, I think, Madam Hearing Officer, we can take a break.
All righty, let's take 10 minutes because we're going to take another 10-minute break. All right, we are back after a short break. Ms. Richards, do you have more questions of the department panel?
Yes, ma'am. The court reporter has asked me to holler, so I apologize if I sound like I'm hollering. Mr. Colony, you mentioned that there is a rating worksheet that EPA uses for major minor designation. Is that correct?
Yes, ma'am.
And do you know whether New Mexico is going to be using that same worksheet?
That will be a component of implementation that's yet to be figured out, but I would assume so. It's used in pretty much all the states that implement the NPDES program.
Ms. Lemon, does the rulemaking or does the rule currently provide that you'll be using that type of worksheet and those factors?
The rules, like I said, provide for the different factors that go into an application.
And so nothing beyond the factors that are currently in the rulemaking will be added to a worksheet to make the major minor determination. Is that correct?
I believe so. I'm not sure what I'm not quite sure about your question. So
let me give you an example. In another rulemaking that I've been engaged in, there were 5 factors for environmental criteria outlined in the regulation that was approved by a particular board. And yet, the department in their interpretation decided to add 2 additional factors. Those 2 additional factors substantially changed the nature of the mapping that was subsequently performed. And the board had no continuing jurisdiction to correct that. So my questions are designed to ask, are you solely following the factors in the rulemaking, or do you believe your department will have the discretion to add additional factors that could change the designation of major minor or fees or other types of standards?
I believe that the rules we will be implementing the rules as they are designed and as they state. For different discharges, we may look at different factors, but the determination for major, minor, or complexity will be consistent with the rules.
And limited to what is in the rules.
Yes, that has not been developed. So I would say yes. I don't have it in front of me, but this is the rule that we are implementing.
Would it make sense for a modification to the rule allow for the commission to have continuing jurisdiction to consider the factors used in, for example, the major minor determination or the mapping to prevent the need for a second rulemaking?
I would say that if a permittee is dissatisfied with our determination and the permit that we draft, you have an avenue to appeal to the commission. You have an avenue to appeal to the Court of Appeals.
But if all these factors are missing from the rule, what are they really appealing?
Those are hypothetical factors that you're talking about. So I don't know what they're appealing.
So I think what I'm hearing you say is these factors don't exist yet. The department hasn't created them.
The factors are in the rule is what I'm saying.
But the implementation of the department doesn't exist. Is that correct?
The department will implement the rule.
And nothing more than that.
We don't have authority to do more than that.
So then would the department be opposed to proposed rule change that would allow continuing jurisdiction of the commission to review those implementing factors in those sheets when they come out?
Say that again, please.
Would the department object to a modification in the rule that would allow the commission to review and approve the worksheets and mapping when the department creates them?
Our implementation guidance is to help implement the rule. I think the commission is to design the rule just like the legislature designs the statute and the department designs the guidance and implementation procedures.
So what I'm hearing is you would object to that modification in the rule.
It depends on what it said, honestly.
So conceptually, you might be okay with it, but you would depend on exactly what that language is.
I mean, we're open to any rulemaking. So it depends on what the language is. I cannot say.
Let me ask you about the mapping. I understand some map will be developed. I'm not sure what the content of the map will be. So the mapping that you will be doing, would it be to identify every ephemeral reach, intermittent reach, and navigable waters of the U.S.?
We do not make jurisdictional determinations for waters of the U.S. That is not something that a state does. It's a federal jurisdiction matter. What the map is intended to do is show the surface water resources within New Mexico to help identify which regulatory agency they should contact. So if you have a discharge or a project, you can look at your project area or the stream you're discharging to or the surface water you're discharging to and identify, oh, I should talk to New Mexico Environment Department, or I should talk to the Army Corps of Engineers. It's a tool. It's not a jurisdictional determination. It's a map.
No, I understand that, but I'm trying to understand what the map will include. And I'm trying to drill down to that a little bit more closely. So if you would include surface water resources, some managed by Army Corps, wouldn't you also do the same for other waters?
It's surface waters of the state and our surface water resources that will be in the map. So I'm not sure what you're getting at.
Well, you broke the map down to say state versus Army Corps, but I understood that you were seeking primacy of the 404 permitting as well.
We are not.
Okay.
Nope.
So then you're doing dredge and fill solely for the state designated waters.
That's correct.
And Army Corps wouldn't be involved with that then, would they?
No, but there may be questions where we have to talk with the Corps to determine if it's a federal jurisdiction or a state jurisdiction, but we're not taking over that federal jurisdiction.
Would you be designating different waters such as ephemeral or intermittent status?
We will have, currently we have different data layers that show those distinctions.
And would the data layers in this mapping tool also include that this is a navigable water, just so that people would have some ease and one-stop shopping?
No, because we don't have that data layer. We don't have, the Corps does not have a map of all the jurisdictional waters.
So then, am I correct in understanding that this layering map will only have, I guess, identification of this is ephemeral water in New Mexico, this is intermittent water in New Mexico, and stop there?
It will show the surface waters within New Mexico, whether, remember, surface waters of the state are all waters. So it could be the Rio Grande, it could be the Pecos, which are waters of the US. But it's also going to show our other surface waters of the state. So to show our surface water resources.
Can you, I guess, just tell me then, you said you have different layers, and if all of these water bodies are surface water, why would you need more than one layer? I'm just really trying to understand this map.
So GIS, we're taking different data that is available and merging it into a data set. So we have data from the USGS, we have data from the National Wetlands Inventory, we have data from our own mapping efforts. So we're using available data for the state of New Mexico and overlaying those layers to create a state map. So in the end, you will see the state resources as basically one layer, but it's a merging of a bunch of different layers, data sets.
And the data sets are things like hydrological flow or other type, what's the data?
It's GIS data, which is used to spatially, it's just like a map. If you looked at a map and you see a blue line,
it's just location.
Yeah, but it's based on elevation, slope, you know, precipitation. It'll show where the surface waters are and have that layer, that geospatial layer for the state of New Mexico.
But and not distinguishing between like flows or ephemeral or intermittent status.
I would have to check with staff who are developing that, but there is metadata associated with those data layers that have different identifiers.
Okay. Madam Hearing Officer, can you tell me how much time I have left? I'm thinking about half an hour. Or... Thank you. Ms. Lemon, can you, so I've been hearing a lot about, there's going to be a lot of interpretive memos and guidance memos. There's going to be an interpretive memo on functions of aquatic features, guidance, surface water map designation, not designation, but surface water mapping, compensatory mitigation requirements, erosion features, permit writing and drafting. And I think the nexus test that Mr. Ackerman talked about on the first day of hearing. Did I grab the whole list of interpretive memos, or are there more? And this is just from your testimony and the earlier panel's testimony so far.
Right. Typically, when you have a program that you're implementing, you have different procedures and guidelines to implement the program so that staff can implement the program consistently, no matter who's developing a permit, who's going out and conducting an inspection, who is looking at a complaint. So there are different, you're calling them interpretive memos. They are guidance documents, standard operating procedures, quality assurance, quality control, things that are inherently exist in all different regulatory programs, yes.
But again, outside of the department and how they're going to implement the program memos, all these things, this commission, without a change in the rulemaking, doesn't have continued jurisdiction to consider whether that meets the intent of the rule that they've passed. Isn't that correct?
Again, if there is a problem with the way the department is interpreting the rule, there will be an appeal to our decision on how we've drafted a permit, how we've enforced on a permittee, whatever that process is, it will come before the commission.
But outside of having a permit denied, having an application denied, without that denial, without that action, there's nothing to appeal, is there? If somebody says, look, I think this, I don't want to spend $300,000 on a permit application when I see your guidance memo is flawed, that's a lot of money for someone to put up, even $100,000 for a smaller entity. So if there's a concern of right, there's nothing to appeal yet because there's been no action to appeal. It's just a concern about these interpretive memos.
You can appeal that decision.
What decision?
If you said a denial?
No, I said if there is no denial yet, that an applicant looks at the rule and says, well, wait a second, that doesn't align with the rulemaking. I don't want to spend $100,000 knowing the department is going to interpret it this way, knowing I'm going to be here for getting the application done and then going through the process with the department, then getting denied, then going to the commission, having a hearing, then maybe going to a court. So absent the actual denial, there's nothing to appeal, is there?
How do you know we're going to do something? Typically when a permit or a program permit writer, we're in communication with the permittee, currently we're in communication with EPA, we're developing it and we're talking, and it's not in a vacuum. When we draft a permit, you can appeal the draft permit. When we issue a permit, you can appeal the permit issuance. When we go down, there is a process for appealing that process if you are dissatisfied.
So Ms. Lemon, I understand there's a process if you're dissatisfied when you have actually been denied a permit. But what I'm saying is, why would you even apply for a permit if the interpretive guidance memo that the department created has an error, a flaw, or a concern? Because the commission wouldn't have continuing jurisdiction to hear it yet because there's no action to appeal. So where is the checks and balances on the department's guidance for this new program? I'm just looking for checks and balances.
Yeah, I don't quite understand where, because you submit your application. If there's a problem, if we deny a permit, we're not going to receive that material. We're going to deny the permit, provide the reasons. I don't know. I'm not sure. I'm not following your logic.
Okay, let's move on. Is there any discretionary factors? Oh, I'm sorry. You guys, if you need a second, that's fine. Are there any discretionary factors that'll be in the department's worksheets for determining like major and minor status? Is there just we think there's an additional factor that's not outlined here?
It's a worksheet, which is a standard operating procedure. So that provides the consistency on working through a permit development.
And there's no discretionary category or factor?
You want
yeah, the worksheet does contain a discretionary component to it. If the permit writer is reviewing it and the other factors don't trigger major, the permit writer, if they're following the worksheet, does have flexibility to note a reason why they would deem it to be a major as opposed to
even if the other factors didn't come to that conclusion.
Yeah. We'll say I have not seen that done in my case.
Oh, Mr. Conley, did you have an opportunity to look at the state of Colorado's surface water rule by any chance?
Then are you talking about the new dredge and fill fees? I have seen their new dredge and fill fee. I don't recall them off the top of my head. I know that they are higher than ours.
So outside of the fees, when you looked at Colorado, were there additional clarifications or criteria in Colorado's view rule that are not in New Mexico's?
I don't recall.
Okay. Ms. Lemon, there's been a lot of talk and discussion about the 96% of waters in New Mexico no longer protected under federal law. Do you recall those discussions?
Yes.
And isn't it true that even before before the Supreme Court considered the congressional language of the Clean Water Act, that the Clean Water Act didn't regulate point source discharges in all ephemeral bodies? Is that correct?
They did regulate discharges to ephemerals, maybe not all ephemerals.
Are you familiar with or know if the exclusion of permit requirements for ephemeral bodies were based on the significant nexus assessment or test?
I am not aware. I don't know.
But you are aware that there was a process by which it was considered whether a ephemeral body of water flowed into navigable waters. Is that correct?
I don't know.
Ms. Saki-Delic, did you have something to add?
The significant nexus test had nothing to do with whether it was ephemeral, intermittent, or perennial. It had to do with whether it was a non-RPW being a non-relatively permanent water or a relatively permanent water as termed by the Army Corps of Engineers. So those terms are actually not interchangeable.
Actually, that's exactly what I was trying to get to with Ms. Lemon, was that there was a decision made as to whether or not ephemeral water bodies flowed into navigable rivers and whether or not they would be permitted.
Ephemeral water bodies could be determined under the significant nexus test to be have a significant nexus. Okay, so non-RPWs under the significant nexus test could be found to have a significant nexus to downstream water bodies. Ephemerals could fall within non-RPWs.
And would you mind for the court telling what RPW stands for?
I just did. Relatively permanent water.
I just wanted to make sure that she got it. Thank you.
No problem.
Ms. Lemon, prior to the decision in Sackett, what percentage of ephemeral waters were not covered by the Clean Water Act in New Mexico?
That the 96% number is how many ephemerals we have, which now 100% are not protected by the Supreme Court's decision. Prior to Sackett, I would have to run the analysis. I did not look at that prior to Sackett, but it was definitely some ephemerals were included, some intermittents were included, some perennials were included, some were excluded. So it wasn't all perennial, all intermittent, all ephemeral prior to Sackett.
So can you say what percentage of waters in New Mexico were covered or protected under the Clean Water Act prior to Sackett versus post-Sackett?
The percentage, no, I cannot say. I can say that prior to Sackett, EPA permitted and the Corps permitted to various different types of water bodies, including intermittent and sometimes ephemeral. There again, it wasn't just Sackett that narrowed down the scope of the Clean Water Act jurisdiction. It's been happening over time since the early 2000s, late 90s. So it's not just Sackett. Sackett was the final determination where definitely ephemerals were out.
Well, I understand that is one perspective, but we know that there's some court decisions that apply for New Mexico and some that don't. So it seems to me there was discussion about Rapinos. And do you remember that discussion on the first day of hearing, the Rapinos decision in 2006?
I don't. I know what Rapinos is, but I don't recall the discussion.
So when you say the changes in the drawing back in the Clean Water Act, I guess what I'm wondering is, you understand that the courts, federal or state, review language that state or federal legislator passes and decides what the intent of that legislature was, right?
What the intent? Yeah, that's what courts are for.
So getting back to just understanding, because there's been a lot of talk about 96% of the waters are now not covered. We don't really have an understanding as to whether or not the Clean Water Act, for example, covered 90% beforehand or 80%. We just don't know because there wasn't an assessment done, was there?
We know now what is happening, and ephemerals are out. They do not make up that full 96%. It's around 88%. And then the rest are intermittent streams. Those are the non-perennial streams, that 96% figure. They're at risk too, maybe not out because we don't know how the EPA or the Corps is going to interpret, but in the new definition, ephemerals are out.
And you're talking about the rule proposed by EPA in November of 2025?
The definition of waters of the U.S.
That is proposed in the U.S. EPA rule in November of 25?
Based on the SACIT decision, yeah.
Okay. And under SACIT, the Clean Water Act extends to wetlands with continuous surface connection to bodies that are waters of the United States. Is that correct?
Yes, they have to have a continuous surface connection that is indistinguishable from the jurisdictional water.
And in looking at the department's rule, is it generally the intent that every single water body in New Mexico, if it could be subject to a point source discharge, will require a permit?
Or if it's a surface water of the state, it will require a permit.
Can you tell me what would not be considered a surface water? Based on your definition, what would not be included as a surface water?
A water of the United States, which will fall under the federal program, and erosional features.
So outside of erosional features, everything else is going to need a point source discharge permit.
If you have a point source discharge of pollutants, yeah. And that could be a general permit or an individual permit.
I'm wondering, there has been at different times redesignations of water body status, such as moving from intermittent to ephemeral, correct?
Yes, there is a process in our water quality standards to do that.
And what's the purpose of that? Why would somebody ask to have a water body redesignated from intermittent to ephemeral?
The standards are different for intermittent and ephemeral streams.
Permitting standards or water quality standards?
Both.
And under your new permitting scheme, would there be any appreciable difference between a water body that is intermittent or ephemeral for the permitting purposes? Like, I'm trying to see what would be the difference in a permit, because you have to have one.
The permit requirements are based on the water quality standards. So it depends on one, if it's a general permit or individual permit. If it's an individual permit and you require effluent limitations, we look at the water quality standards to develop those effluent limitations.
And so the only difference would be perhaps effluent standard. That you get a permit, effluent standard might be a little different for an ephemeral reach versus an intermittent.
Versus any other, like each water body has different sets of standards that we apply. Yes.
So does this list, the designation, does it still have relevance under this rule? The designation of this is an ephemeral reach, this is an intermittent reach, does it continue to have relevance under this rulemaking for the permitting criteria?
again, we use the water quality standards for ephemeral streams to develop a permit for discharge to an ephemeral. We would use the intermittent criteria to develop a permit for an intermittent stream. It depends on where you are discharging and those water quality standards that you have to meet.
So I think what I'm hearing is yes, it still has relevance because it would flow into what the permit requirements will result in.
Which is how it's always been.
I'm just trying to understand again if there's still relevance to that process, since we had recently gone through a very extensive process in doing just that. Ms. Lemon, is it true that agricultural sources can have, agricultural discharge can have a significant impact on water quality?
Is it true
that agricultural discharges can have a significant impact on water quality?
Like what?
Use of fertilizer, I mean, there is some pollutants that can occur due to the agricultural process, right?
Yeah, there are non-point sources that come out. You're talking about agricultural storm flow, which is non-point source and not regulated.
Right, but let me ask you this. If an agricultural enterprise decided that, we're in an area that the flow is problematic, if it were to rain, it would kill all of this particular product. That can happen, right? Oh, too much water at a period of time. And they decided to create a channel to flow off somewhere. Would that become a point source for which a permit would be needed in the agricultural realm?
I don't understand the question or the hypothetical situation.
Okay, let's say you have an acre and you've got trenches because you've got peas. You've got peas growing, and this particular pea is very sensitive to waterlogging. So an agricultural service decides to build a channel. So if there's a sudden rainstorm, monsoons that happen, it flows that water off very quickly. Would that need a point source discharge permit? If they built a channel to move the water off quickly?
I don't understand the hypothetical. It's I would assume that's under normal farming activities, but I don't know.
So,
because I don't understand exactly what you're talking about.
There's an agricultural exemption, right?
There are, yes.
And what is the agricultural exemption cover?
Well, it depends on if it's a point source or if it's a dredge and fill. So what are you talking about?
So that's my question to you. If a farmer built a channel to flow water off the farm quickly, would that become a point source, which would then require them to get a permit when they're already exempted?
I think we say that agricultural storm flow is exempt in the exemptions. And that is agricultural storm flow.
All right. And then so it would be the same where it is agricultural storm flow. They built a channel, but they lined it with rock this time. Still exempted under the agricultural storm flow.
I don't know.
Okay.
Again, like hypothetical situation, if it comes into play, I will get back to you.
I'm just trying to understand the application of the exemption, that's all. Let me ask you about some timelines in the permit application process. A person has a meeting with the department, they submit their permit application for, let's say, a NMAC permit. Can you tell me the next step and the timing in that?
What section are you talking about? I don't think I covered this in my testimony. I think this is Dr. Fuad's testimony.
Okay, as you are the chief that oversees the operation of this program, right?
I am.
I'm just trying to understand what your understanding of the timing of the process is. How long is it going to take to get a permit, essentially?
Right, and Dr. Fuad will talk about that when he testifies.
Is there any enforcement provision in the rulemaking that would allow a permittee or putative permittee to move to enforce against the department for not timely getting to its permit?
In which rule?
For the NMIPDs.
NMIPDs. I mean, Mr. Connolly talked a lot about permit backlog, so it is an issue with other states for the enforcement under NMIPDs. It's more of enforcement of compliance orders or the permit related defenses. I'm not sure if there's something, I don't know. I would have to like go through and see, and Miss Lucas Kamat or Dr. Fuad may be able to better answer that question.
Okay, I think I'm done with questions. Thank you.
Thank you, Ms. Richards. Mr. Micklejohn, do you have questions of this department panel? Mr. Micklejohn declined. Ms. Fox, do you have questions of this department panel? Thank you.
Madam Hearing Officer, Commissioners, my name is Tanis Fox. I'm a lawyer with Western Environmental Law Center, representing Amigos Bravos, New Mexico Acequia Association, and New Mexico Wilderness Alliance. Good afternoon, everybody on the panel. Just a very few questions for you, Ms. Lemon. Ms. Richards just posited a situation in which an entity would be potentially required to spend $100,000 or $300,000 developing a permit application, I guess under protest, because they didn't think they needed a permit. And she posited the situation that there wouldn't be an appeal process until all that money and time and effort was expended. Do you remember that line of questioning?
Yes.
Now, in the real world, if an entity doesn't believe it needs a permit from NMED, does that entity generally start the application process for a permit that it thinks it doesn't need?
No.
In that situation, isn't the more likely scenario if there's a situation where NMED believes an entity needs a permit and that entity doesn't, the entity doesn't apply for a permit, and what NMED does is take an enforcement action against that entity, saying it's discharging without a permit, or for a future discharge it needs a permit. Isn't that what happens in the real world?
Since I don't have the permitting program, but that is how it's happened with the groundwater permitting program. So yes.
And so NMED would bring a compliance act, either a compliance action, administrative compliance action, or a court case, litigation against the entity that I thought was out of compliance, and that entity would have an immediate remedy, correct?
Yes.
That's all I have.
Thank you, Ms. Fox. Ms. Udall? Ms. Udall, can you unmute yourself?
Thank you. No questions.
Oh, thank you very much. Let's turn to the commissioners. I'll start on this side this time. Commissioner Laney, do you have questions of this panel?
Yes, I do. Just one moment. And I'll pull up my So I'll do my best not to ask duplicative questions. So if it takes me a minute to find my place, I just ask for your patience. Okay. So anybody who's appropriate on the panel, if you would answer, is appreciated. You guys seem to share some subject matter expertise in all of this. So what technical methodology will be used for the jurisdictional determinations?
I don't know if we said we were doing jurisdictional determinations.
I apologize. I meant for the waters of the state.
So waters of the state, we have different, like I said, technical tools that we will be using. One is the map to help identify if surface water resources are going to get impacted or potentially impacted. Others would be site visits if we're not certain or we need better clarification. And the information that's submitted in the application to help identify what resources are impacted, what the quality of the discharge would be, and things like that.
So is there any way currently for an applicant to challenge a determination of a feature?
A feature, whether or not they need a permit?
Yes.
I believe that's what we just covered. If and nobody's has to apply. If they think they don't need a permit, they don't have to apply.
So
apologies.
I guess I'm just curious, what if they don't know if they need a permit?
Right. So we have a lot of those calls, and picking up the phone and talking to the regulatory agency is probably the best avenue to have a quick conversation. We also have pre-application meetings that we can talk with not just the department, but other agencies that oversee water and natural resources, and also historic cultural resources. So we do have opportunities to talk through that prior to application, and that is probably the best avenue. If they have questions, let us know.
I asked this during the first panel, and I think it's largely been answered, but for my own benefit, I'm going to ask again. Where in the rule are there objective criteria for determining whether a particular landscape feature is a regulated surface water of the state?
I don't think there is. It's the definition of surface water of the state, which excludes waters of the U.S. Well, in Exhibit 79A and B, excludes waters of the United States and erosional features.
Let me scroll a minute here. Apologies. So, are there categories of water regulated under the proposed rule that were previously never regulated under federal law?
I don't believe so. It's hard to say going back, but I don't believe so.
Okay, yeah, I'm just kind of curious if that was data or information that you guys had compiled. So go to the next scrolling session. Okay, this was another one that I had previously asked, and it may be slightly redundant, so I apologize in advance. What specific provisions provide regulatory certainty to a individual, an entity, a landowner, attempting to determine whether a permit is required before undertaking work in an ephemeral drainage? What regulatory certainty? Ephemerals are listed as a surface water of the state, so it should just be assumed that they have to have a permit. And it may be a general permit. Again, it depends on the activity, but if there are questions, they are certainly able to look at the map or identifying if it's a feature on the map, talking with us prior to application to figure out if or how they need to apply. So there are, I don't know if there's anything specific in the rule, but we have processes for that as far as pre-applications, content in your notice of intent, but the definition of surface water of the state has ephemeral. Okay, I'm so in my head, I'm envisioning that, you know, meeting the new definition. Well, it's not really new, but the expansion of this surface waters of New Mexico will capture ephemerals that the folks may not know need permitting. And I really want to understand how they're supposed to know that they need to be permitted. So that is part of our education and outreach once we have the permitting program. And it's also when landowners do something that they shouldn't be doing, we go out there and talk to them. We tell them, we provide guidance on how to come into compliance before we enforce. So it's not an automatic unless it's totally egregious. They knew they should have done something and they didn't, and we can prove that. It's more of compliance assistance and helping, and our education and outreach that will help with that communication. So there will be some educate before you regulate. Yes. Okay, that's an FDA slogan that I'm very familiar with. Nice. I love it. Sorry, that's the world I live in. Yeah. Anywho, apologies. Okay, so this is a little bit on the dredge and fill side. So these may be best by Miss Zuckadelit. But maybe not too. So I'll let you guys bounce back and forth.
Zocchi-Delit. It's weird. I know. I apologize. I tried tonight not to hyphenate it, just to keep it easier, and that didn't happen.
So I'm going to walk through like a thought process that has some questions attached to it, but just let me go through that. So from what I paraphrased in your testimony, applicants have to demonstrate that there are no practical alternatives with less adverse impacts and must select the least environmentally damaging practical alternative, which is effectively an important major concept of the federal 404 permitting. I see you all nodding your head, so I'm going to keep going. So with that in mind, my question is, and there's multiple parts, I apologize. Where in the rule is the methodology established? So how will NMED determine what is practicable, what is an alternative, how much additional cost makes an alternative impracticable, and who bears the burden of proof?
So first, there's several steps to determine to an alternatives analysis and getting to what I'll call the lead putt. That's what we always called it with the Corps. And what I would say is that's, and Shelley can correct me if I'm wrong, but that's generally, at least when I was with the Corps, collaboration between the applicant and the agency. And you talk about it, the applicant knows what's practicable to them. That has to do with cost, it has to do with location, it has to do with egress, ingress, I mean, all kinds of things, right? So, well, what I would say is that they're going to be developing implementation guidance that will guide that. and also through education and public outreach that they'll be addressing those alternative analysis.
So,
Correct.
so the methodology, as I referred to it, isn't fully mapped out yet.
And to be just like honest, the Corps doesn't really have a whole lot of like just this is how you do it. First it's one, then it's the other. There's a lot of things that go into it, and it really changes depending on what the project is, where it's located, what the need for the project is. I've had commercial developments, including FedEx warehouses. I've permitted Walmarts. I've permitted residential developments, and all of these things have their own set of practicable alternatives and their own alternative analysis. So while you have a general guideline of you're looking at cost, you're looking at location, you're looking at all of these things, it is different, much like the environment. It's different with every single project. And that's just my experience.
So Section 404 has decades of guidance and litigation that surround it. The rule proposal appears to adopt a lot of that in concept, but what I don't see is that kind of analytical framework. So what guidance will a permit writer use when determining whether a proposed project represents the least environmentally damaging practical alternative? That's a mouthful. Yeah, can you, I can state that again if you like. Okay, I'll leave the forward part out where I was transitioning, but what guidance will a permit writer use when determining whether a proposed project represents the least environmentally damaging practicable alternative?
So first off, I believe that requirement is for individual permits. We have some other requirements for general permits. We're anticipating most being general permits for dredge and fill. Right now, the department certifies maybe 1 to 5 individual permits a year. So we're not looking, or based on that, we're not anticipating a lot of individual permits that go into this full-blown analysis. For the analysis, again, we will have standard operating procedures for people to go through to make sure that the process is consistent and permit writers are maintaining and evaluating consistently. But again, each project is going to have its own special little things that you have to look at because of where they are, what the project is, how much they're disturbing, what is going on in that project area, how big the project area is. So our standard operating procedures on how we develop permits is what they will be using as their guide. Okay, so there's several areas where it says, the secretary may require mitigation, or the secretary may waive mitigation, or the secretary may impose additional permit conditions. This is language. This creates a potential administrative law issue, but not because the discretion is improper, but because of the broad discretion generally requires clear standards. So what standards constrains the secretary exercising the discretion regarding mitigation, waivers, and permit conditions? I lost the thought again, so can you repeat that? Yes, so it's getting to the end of the day. This is hard for me too. So there's several times in the document in the testimony where it says, the secretary may require mitigation, they may waive mitigation, or they may impose additional permit conditions. Discretion generally requires a clear standard for which they're applying the discretion against or for. So what standards constrains the secretary's exercising of discretion regarding mitigation, waivers, and permit conditions? So I think that in that discretion and in the permit, when we issue a draft permit, we have to support the decisions for that draft permit with all of the supporting documentation, the technical information, the data. So that fact sheet or the statement of basis, depending on what action is happening, explains the secretary's rationale and is part of that public comment period and public input period, or, you know, appealing decision, like, we don't agree with this decision. But that fact sheet, it's not just, oh, I want to do this. You have to support it in the fact sheet and the statement of basis.
This is switching gears a little bit, and I don't know if Mr. Conley will answer this or who may want to answer this, but I'm curious. There was a number in the presentation, and I believe in the testimony of 200 annual dredge and fill permits. Is that for individual permits or is that for general permits?
For general permits.
Okay, sorry, I just missed it, so I wanted to get an understanding. Is there an estimate for individual permits?
2 to 4.
2
to 4 each.
Okay, thank you. Yep, that's how I missed it. Those numbers just didn't stick in my head. Thank you. Okay. Okay, so under the enforcement assumption, there is an estimated 17.1 FTEs for enforcement support. Of that, 9.7 FTEs are devoted to investigations involving non-permitted activities. It's more than half of the enforcement staff. What's the assumption of supporting the allocation of nearly 10 FTEs to investigations of unpermitted activities? Does NMDA expect substantial non-compliance?
That is a default recommended by EPA. It came out of their work groups based on data submitted by states. That is the assumption based on the permitting universe that they will encounter and be called upon to investigate.
I don't know how reflective that is of New Mexico.
I understand.
Yeah, I mean, we're dealing with, we don't know because we don't have the program. It hasn't been implemented. So using a default at this time is the best.
Sure.
And that default is based on EPA and states who actually have programs and our permitting universe that is known at this time.
I have a number of compliance enforcement experts that work with me. I'm also a compliance inspector, but I have folks that have been doing it full time for 20 years. And I did ask them about that number and they didn't think it was crazy. But I will say, when I see it in the model, I too am shocked at it.
Yeah, I mean, I may not have the correct perspective of what New Mexico's surface water permit program is going to look like, but to me, it seemed like a large number, which then made me question, was the assumption that there was going to be a ton of non-compliance or folks that were not getting permits when they should.
No, it doesn't even mean that there are people who should have permits and don't have permits. Somebody could be illegally dumping something and they could get a call to go send their inspector out to them.
Okay, so I'm going to float through some questions here. I think several of these have been answered. They were on your presentation, sir, so just bear with me a second. Or if it's more appropriate to hand this off and come back to me, I'm fine with that too. Don't know what, doesn't matter. Keep going. Okay. Go I will then. So this is just curiosity, and I think this was covered, but I just want to make sure I understood. The regulation under 20.6.2.2350C and 20.6.5601C requires NMED to recalculate the annual fee rates each year by April. If annual program expense costs increase due to inflation, staff raises, or program expansion, what limits, if any, exist on fee increases in the subsequent year? Is there a cap, a notice requirement, or how is that controlled?
My understanding of how the regs are written is there's only one opportunity every 3 years to adjust by CPI.
So that's the CPI adjustment. Okay, I do have some questions there. So that's every 3 years, correct? And they take the average of those 3 years?
They would take a cumulative CPI.
Right. So from my understanding, and maybe I've misunderstood this, on average, annually, CPI increases about 2.5%. So if you used that, what would 3 years increase look like?
I would have to.
No, it's fair. It's
make sure I was doing that right.
One at a time. Apologies. No, that's fair. I'm not going to ask you to calculate. I was just curious if there was an average number that you had played with to kind of look at how these permit fees would increase over time.
I have not played with the numbers to see how they would increase the CPI. I assume since CPI is supposed to represent a real world value of the dollar, it would be commensurate with today's value.
So I took the 322,000 and just did 2.5%, which would increase it by 46,830, leaving it as a $234,152 permit fee.
2.5% did that?
2. Oh, you're right. I forgot a zero. See, this is what happens when I do math after lunch. Thank you. That was a very good catch. Please scratch that. Okay, scratch that. I just wanted to understand what that would look like. And I didn't know if you guys had prepared anything that kind of explained what that increase would look like, but thank you.
Somebody's awake.
Thank goodness. Okay. It's covered. We did talk about this some, but I'll ask this question anyways. The cost model was built around EPA's national NIPD's costing tool, then calibrated to New Mexico through discussions with NMAC staff and benchmarking against Idaho. Is that correct?
I wouldn't say we benchmarked against Idaho. We discussed program development with Idaho, which included discussions of ensuring being fully funded and some elements of cost associated with program.
Can you elaborate a little bit further? I want to understand where Idaho comes into this kind of calibration, because to me, they're significantly different than the state of New Mexico.
I would say they were more of a gut check on what we were doing. They did not. I would, and Shelley, you can correct me if I'm wrong, but I don't believe they impacted our numbers. We didn't go back and modify things after our discussions. We felt more confident.
So is it just like a check of how they used the tool?
I believe we did talk about the tool, but it was more in how are you getting along after using the tool? Was it accurate? Do you feel like you have a well-funded program?
Okay, this one has been talked about, but I still want to ask it. The permittee universe was kind of projected smaller. Is that a good way than what it will likely be?
So for program costing, we try to use the full projected universe, and then coming up with the fees, we use the actual. And that has elevated rates with the idea that at least until program maturity, you are likely not going to have those additional facilities joining. And then, so it's likely going to be the facilities that are currently permitted.
So
initially.
The practical effect then is that the current permittees will pay a higher per facility cost to build the program infrastructure.
There will be some additional costs associated with startup on the initial permit fees, which will be good for funding the initial program membership.
So can you quantify how much of the approximately 8.4 million annual cost is attributed to startup and infrastructure development versus state steady oversight of existing permits? That 8.4 million is for full program maturity. If we could have it at today's rates, right? We know like full program maturity is going to take time. I talked about the phasing of the NMIPT's program. We don't anticipate to have the full universe of NMIPT's permits in our shop until 2032, 2033, as we phase in the program over a period of 6-7 years.
If there's legislative funding to support program development, then of course those fees come down to misery.
Sure, I did see that in the nature of the text. So as my understanding, the fee revenue will deliver a predictable permitting timeline and regulatory efficiency and consistency of regulatory expectations. That's the premise, right?
Largely, yes. I will say when you look at certain permits, like the power plant permit or some of the largest permits here, the development of those are going to take an extended period of time. So typically you want to get a permit out within 6 months. They have to submit their application 6 months prior to expiration, and you want to get their new permit to them prior to expiration. But that is not always going to be possible, even with a well-funded program for the extreme situation.
So will there be program standards, and maybe standard isn't the right word, but it's the only one I have right now, around the permit issuance timeline, inspection frequencies, review turnaround, all of the things that go into the application process? Will there be standards around that the regulated community can expect to move through at a certain rate? We do have timelines in the rule, and I believe Dr. Fouad will talk about that.
Additionally, EPA is going to have a memorandum of understanding with the state that will lay out expectations for the program, including inspection frequency and around things of that nature.
All right, so I've moved through 2 of my documents, which leaves only this last one with very few notes left, I think. Just a question. Will the guidance documents that are going to be used to provide direction for the permits include any standards for which the permit will have to meet? The standards that the permit needs to meet are in the regulations, whether that's 20.6.2, 20.6.5, or the surface water quality standards in 20.6.4. Okay, just wanted to hear that. So then my last one, I don't know that these fees were discussed, or at least I didn't clock it. And so I just have some questions on the 20.6.2.2353 table 1, and then a few more on table 2, but I'll start with table 1. I'm going to skip over because these were covered, all the domestic wastewater permits, the industrial wastewater permits, and the dredge and fill. And I'm going to focus in on like the last 6, I think, here, maybe 7. So starting with this first one that I've highlighted, there's a line for Clean Water Act Section 401 certification, dredge and fill. And I noticed that that certification provision existed in the statute and wasn't really changed. Is that correct? This certification narrative. Right. So you have been certifying in all this time. We have, but not paying it. It's coming out of program funds. Yes. I mean, program, other Surface Water Quality Bureau, the budget.
not specific for this program.
Okay, so I did find it. I don't understand why it's being included as a cost when you've been providing that service all these years.
Because we're looking at restrictions and federal funding and potentially state funding. And this is a service that we provide. Other states also have certification fees, but I realize it may be a surprise to people. So we were trying to, again, try to create a funded program and ensure that we have the ability to continue doing that under the federal program.
So I'm not, I need a little clarity, I suppose. As part of the 404 side of things, they rely on your certification for their permitting process. Do they not?
Yes, well, it depends. Under certification, under Clean Water Act Section 401, the state can issue a certification with conditions. They can issue a certification without conditions. They can waive certification, which, you know, if we don't respond, the Corps can issue the permit. Like we have a timeline to issue our certification, or we can deny certification, which causes all sorts of problems. But you know, that those are the opportunities. So we don't have to issue a certification, but we typically do because we have different criteria for New Mexico.
So would the Corps be responsible for that cost, or would it be the permittee working with the Corps through you? I just want to understand that side of it as well.
The permittee requests certification.
Okay, thank you. I was not clear on how that process worked. So then the rest of these, I can kind of lump them, but we can go through them one by one. I'm not particular. Some of these seem like they're components of the permit. And so I want to understand if this is a separate fee that gets tacked on to the permit. So like the anti-degradation review, well, there could be a requirement for anti-degradation plan. So would the review then cost?
If an anti-degradation review is required, which it won't happen in all instances, and we're the agency who's doing it, it could be contracted out. But if it's the department who is doing these things for the permittee, that's kind of I guess you can think of it as them contracting us for a service.
So that it would be an additional cost if they're asking you or they're enlisting your assistance on that.
Yes.
Okay, so it could be an additional cost to their permit.
It could be.
Okay, and I assume that that is true for the mitigation plan review, the aquatic resource delineation, and those two.
Yes.
Okay. So then I had some questions. So I'm a little bit, when would the agency consultation service fee come into play?
I believe this is for any state agency if we have I think that it would be something that would need to be further talked about, not just in normal discussions of like a pre-application meeting, okay, but if there's further development or resources, special resources that need to be protected, and we need to have further conversation about that.
So this is not intended to be charged for like working with you guys to figure out an application?
No.
Okay, I just wanted to make sure that that wasn't the intention, because that seemed a little crazy if it was.
Yeah.
Okay, and then the surface water discharge permit modification. It seems like a modification can be brought about by several different mechanisms. Either the secretary can say that a modification must be made during a permit review period, modifications could be made. The permittee could bring modifications. Do all of those become subject to that fee?
It's the permittee request for modification. So only if the permittee is requesting the modifications? I believe so. Again, I would need to Ms. Lucas Kamat or Dr. Fuad may be able to better explain that. Okay, yeah, I'll probably ask them because I thought I saw that if it was due to an enforcement action, that they would also be subject to that permit modification fee. But I will, if you don't know immediately, I can hold that and ask. And then the last one on this one is the permittee initiating hearing fee. I did notice that that's something that's also included in the groundwater fees, though it seems to be utilized a bit differently. So when would that fee come into play? I'm assuming if a permittee disputed a provision of the permit and wanted it to go to hearing, that's the logical time at which that would be applicable. Yeah. Are there any other times if a third party issues contends a permit, would that potentially force this permitting fee? I think if it's not the permittee, I'd have to go look to see if there's language in the rule that I'm not thinking of right now. Okay. So just slightly separate from these particular fee lines that we were just talking about, is there protection that prevents repeated permit modification requests from becoming a source of regulatory uncertainty, especially if it's from a third party? I'm not sure I understand. Can you repeat? So I had kind of two questions laid out here. So maybe if I ask both, it'll make both more sense. So let me start over. Could a permit modification request initiated by a third party result in additional compliance for the permittee? What do you mean by additional compliance? Well, there was I didn't write it down, but there's a section in there that if a third party brings substantiated evidence, but you didn't like the word evidence, so substantiated information that suggests that a permittee is not following the scope of their permit, that there could be actions taken. I think our modification section is according to the Water Quality Act. I have to look at the language because typically we don't have modifications in the federal program. It's a rare event, but it is allowable. So let me see if I can find what's in the Water Quality Act. And I think that what I was looking at was under 20.6.2, but I didn't write myself good enough notes. So we might just continue on if it seems like this is headed down a confusing pathway where we won't really get an answer. You need me to stop? I have a few more questions on table 2 and then just some quick questions. So I don't think it'll take very long and we can move on. I don't need you to dwell over this. Yeah, I mean, in 20.6.2, we referenced the Water Quality Act and the procedures in there. So this is just a lack of me really knowing what these permits cover, but under the general permit, there's one that says pesticide general permit. When would that be needed? What does that, what qualifies a pesticide general permit? So for pesticide general permits, it's when you're applying pesticides and it has a probability or you're right along the edge of a surface water or you're in the surface water. We have Department of Wildlife gets pesticide general permits when they are restocking areas. So they kill the non-native. That's considered, I mean, it's a pesticide, but it's under the pesticide general permit. When people are removing non-native riparian vegetation, they use pesticides, and you are under that pesticide general permit. So activities like that.
Okay. So it's kind of when a pesticide is going to be applied to a water to treat an aquatic pest or very near a water for similar reasons.
That's correct.
Okay, thank you. I just needed a little understanding there. Of course, the Department of Ag has a whole pesticide program, and I wanted to make sure I knew where this and that were at. So then I think my last few questions, I just wanted to get a little clarity on the tribal standard regulatory, the tribal standards section. So the rule recognizes the tribal water quality standards. Can you provide me an example where a permittee operating outside of tribal lands may be required to address tribal water quality standards? Is that something like that going to exist?
So yes, it does exist as they're considered downstream states. So even permits that flow into Texas, we have to consider Texas's water quality criteria and water quality standards. So it's that same concept. So one of the facilities that has downstream tribal water quality considerations is Albuquerque Bernalillo County Water Utility Authority. They EPA reviews the Pueblo of Isletas water quality criteria, and the state's water quality criteria, whichever is stringent, is used to develop the limitations in the permit.
Sorry, I believe I'm done.
Terrific. Thank you, Commissioner Laney. Let's take 10 minutes and come back at 4:15. Let's come back from the break, please. We just have 45 more minutes. Hi, Jason. No. Were you tricked? Okay. We need one more witness. Where's Ms. Lemon? Yeah. Oh, okay. La, la, la. Let me ask, I'm at her request, I'm skipping Commissioner Fry for the moment. Commissioner Chapman, would you have questions of one of these two witnesses?
I do, yes.
Great.
Okay. Good afternoon, and thanks for your testimony and being here today. I appreciate all the hard work that you've done to put this program together. Mr. Connolly, I have just a few questions. And so early in your testimony, you referred to program needs in comparison between Region 3 and Region 6. I'm wondering if you can talk a little bit more about like differences in program needs between those regions.
Are you talking about program needs or their existing backlogs?
Program needs.
Yeah. So the only times I remember mentioning them specifically was in relation to the fact that they have backlogs. I was trying to illustrate the fact that states are struggling to have fully funded programs, and that results in backlog. And I was discussing the fact that many of those states continue to have backlogs. And I will acknowledge the states can have backlogs for numerous reasons, but one of the most major being they just don't have the staff capacity to go through and issue those permits. And I benefit from that in many cases. The states will have us come in and write permits for them to help eliminate the backlogs to the extent that they can. So let me see. So yeah, EPA Region 6, Arkansas has a 20.1% backlog, Louisiana 17.3%, Oklahoma is a 6.6% backlog, and Texas is a 19.3%. So, you're looking at about 20% generally, with the exception of Oklahoma, which is doing great. I don't have Region 3 written down here. I assume that's because Region 3 is doing pretty well. Although I am in Region 3, and we did a resource assessment for the various states, and there are some states that are struggling significantly within EPA Region 3 as well. EPA Region 1, the Northeast, has a 57.3% backlog. Unless I could be misreading my handwriting, it could be 53.3%. And then in the Midwest and Region 8, 39% across them. Region 9 is a 41% backlog, and Region 10 is a 61% backlog. So the only reason why I was bringing those up earlier is we really do want to make sure that the program is well funded and retains capacity to, again, provide services commensurate with what the people of New Mexico deserve, the entities applying for permits deserve, and to not burn out the NMAD staff.
Appreciate that. We've heard a little bit about Idaho and sort of the conversations that you had with Idaho in the development of this. I'm wondering if you can just like zoom out and just big picture, what are the most important lessons you learned from Idaho?
They felt that when they used the model, they underestimated some values, which we had fortunately not underestimated those values, and they were very clear that they wished that they had more appropriately estimated levels of effort associated with certain activities.
Cool. Thank you. And then maybe just to dive a little bit into this idea of uncertainty and where that exists in the models that you developed. You talk about uncertainty and the use of professional judgment to avoid underestimating resource needs. What are some examples of the largest uncertainties with respect to cost estimates?
Well, one would be what was brought up earlier, right? The compliance and enforcement, the inspections of the non-permittees is a big component in using EPA's default there, because that is a metric that otherwise I would not have data on. I would say in most cases, we just don't know what each individual permit is going to cost. We can assume some median or average values, which is what you end up doing. I do it all the time. We have to compete for work in individual states, and they say we have 5 permits, and they might say what type of permits they are, and we try to estimate level of effort of what it's there in order to do it. So with New Mexico estimating, essentially a 500-hour, that there's uncertainty with all the level of effort estimates. I mean, that's the nature of it until we gain some data and have our procedures drafted, have staff trained up, and have a better idea of what New Mexico staff are and procedures are capable of producing.
Cool. Just maybe keeping this theme of reveling in this complexity and uncertainties, lack of data, historical reporting about activities that affect ephemeral streams and how that represents uncertainty for a program like this. Are there other states that you can use as models to understand ephemeral activities and how that could be a contributor?
Like the 404, you're talking about the dredge and fill
sure,
assessments. Yeah. I feel like we have a pretty good estimate. I mean, the historical data indicating almost 200 on the nose makes me feel, it's uncertain. We're not there yet. We don't see those permittees, but I feel we've done as close as we could to hitting that one as well.
Well, thank you. And then the rest of my questions are for Ms. Lemon. So, we're end of day 3 here, and we've gotten really into the minutia of a lot of these things. And so I want to spend a little bit of time zooming out a little bit. And so we've heard about this gap and vacuum that this Sackett decision has made in terms of sort of like this high level, what it means for the state. I'm curious about your perspective and from a programmatic view, like how does that affect your programmatic perspective And what does this look like on a day-to-day operations level? This vacuum, this gap.
So programmatically, I mean, it's not necessarily programmatically. I think of it as statewide issue for any citizen who values water quality. Looking at a perennial test, a relatively permanent test to determine federal jurisdiction is really disconcerting in a semi-arid state where we don't have very many flowing rivers and streams or wetlands or wet areas. So that knowing the benefit of a functioning stream and having water quality that can meet designated uses like recreation, agriculture, drinking water, all cultural uses, all of those things, that's super important. And if you're only looking at relatively permanent waters being permitted, that leaves the vast majority of our waters open to regulation, and I mean open to pollution and at risk for pollution and contamination. So that's where the concern, broadly speaking, not programmatically, but as living in New Mexico, you know, having my family here, that's what I look at.
Thank you. This hearing, this rulemaking is literally years in the making, and so I'm wondering if you can summarize high level consultation with EPA and what it has looked like, and then what it will look like going forward as the program matures.
So we've been talking with EPA Region 6 and EPA headquarters from the beginning, from when it was an idea of like, hey, we're thinking about primacy. EPA Region 6 actually for years, this isn't the first time we've tried to do this in the state. There have been several attempts. This is the first time that we're actually doing it. And Region 6 in history, over history, has asked us when we're going to take over the program. So they've been questioning us for years, probably my entire tenure at the Surface Water Quality Bureau. But they've been involved since the beginning. We've been talking with them about the statute when we were pushing Senate Bill 21. They reviewed Senate Bill 21. They've reviewed our draft rules. We were in communication with them right before, which some of the changes in Exhibit 79 were based on some EPA feedback. So when we move forward, as we develop the application, once the rules are approved, and we're looking at the MOA, we're going to be talking to EPA about how the program, what each role is going to be for the department and for EPA, and what the requirements are, how we're going to phase in. That whole application process is going to be iterative. We want to make sure we both, as the federal agency and the state agency, understand our co-regulator responsibilities. That once it's approved, EPA does public notice the application and the program on the Federal Register for public review and comment, and then we go forward with authorization. Once we're authorized, EPA is going to have oversight of the permits. So we'll be issuing permits there. It's going to be kind of like a reversal of what's happening right now. We'll be issuing the permits, they'll be reviewing it and looking at it to make sure that the permits we issue that are federal NMIPD's permits are meeting the federal requirements. So that's kind of the process.
Yeah, thank you. I was really, as a big data person myself, I was pleased to hear about this mapping tool to provide, clarity about different surface waters of the states, of the state. We heard a little bit about it already and what it sort of entails. I'm wondering if you can just like high level what the goal of the map is and who the audience is for that.
The goal of the map is just to help people look at surface waters and determine who may be the regulated entity. Again, we're not making jurisdictional determination, like this is not a map for jurisdictional determinations, but it's to help people identify who they should talk to. If there are special resources near their project area, or surface water resources, aquatic resources near their project area or discharge, it can be used by anyone really who wants to look at aquatic resources and that type of resource in our state. So it's not just for the regulated community or for NMED, but it's really for anyone who needs to or who is interested in surface water in the state.
Thank you. One final question, and this, there's been numbers of permits been thrown around, 200 here, whatever. The total number of 4,000 permittees, I think, was a number that I heard. Can you talk about logistics, your perspective, the department's perspective of overseeing that many permits?
So the 4,000 number is broken out into general permits and individual permits. The individual permit universe right now under the NIPD's program is a little over 100, maybe 110, 115. With the Army Corps of Engineers, they, like I said, we certify between 1 and 5 individual permits. So that's what we're kind of using for our estimate under the state program. Like not a lot, maybe not even any. They might all be under the Corps still. And then the bulk of it is under the general permits. We're looking at that general permits, not 4,000 different general permits, but 4,000 general permit coverages. So permittees operating under a general permit. In the NIPD's world, construction general permits has the highest number of permittees. I think it's anywhere between 3,000 and 5,000, depending on construction activities. And then it's the multi-sector general permit for industrial stormwater, which is 500 to 600 general permit coverages. So we have a bunch of permittees, but not as many general permits. Probably, I would say maybe 10 general permits, 15 that we'll be issuing as general permits, and then all of those thousands of people who will apply for coverage under them.
Gotcha. Thank you. I don't believe you were in the room when I thanked the rest of the panel for your testimony, so appreciate it. And that's all my questions. Thank you.
Thank you, Commissioner Chapman, Commissioner Thompson.
Thank you, and it's been very enlightening. I appreciate all your testimony. I'm going to start with Miss Zeki Dalit.
Yes,
and
sir.
again, I apologize. This has everyone. It's just it's uncommon. And I just have. I'll find it first. Yeah, this is a question was sparked by Mr. Mento with Sandia National Labs, and we're talking about dredge and fill, and it requires a functional assessment of the watershed, or at least of the channel. Is that correct?
That is not correct. A functional assessment is generally only done when you're trying to assess a water and the impact that you are proposing to make to that water in contrast to the mitigation that you might be proposing. So let's say that you're impacting a half an acre of a wetland to certain function, right? And you're proposing a half an acre of a different wetland. And you want to make sure that the mitigation functions are matching what those impacts lost are. So you're gaining as much as you're losing. you don't just go in and functionally assess a stream unless you, or any other water, unless you actually have a goal of something. And that's generally in the permitting world, that's usually when those functional assessments are used.
Okay, thank you. So, a couple months ago, we approved a revised stream standard for the Tajeres Arroyo, which flows through Sandia National Laboratories, which I suspect was its principal concern. It's a large sand bottom channel. There is no wetland. There's no water. Maybe 4 or 5 days a year there's wet water. It is a problem from a management perspective because something on the order of 5 to 10,000 cubic yards of sediment are moved down this channel each year. Would a situation like that require a functional assessment before they could go in and start moving a sediment out of the channel?
I would say that it really depends on, number one, what's the need of it. Would that possible project maybe qualify for some kind of exemption? Yeah, compensatory mitigation might be required if they're needing a permit and they're required to have compensatory mitigation, then yes, you would want to do a functional assessment. Does that make sense, or did I?
Yeah, it does. But again, for that particular channel, there is no wetland.
Functional assessments are not just for wetlands. I just used an example of a wetland. There are functional assessments for streams as well.
So you're sort of implying they have to do a functional assessment.
I would recommend a functional assessment if the person writing the permit is requiring, or the agency is requiring, compensatory mitigation. What that does is that ensures that those values from the stream that the stream is providing are offset by the mitigation appropriately. Now understand that a lot of people, when you start talking about mitigation being required, they're thinking these pristine, beautiful, and you're going to have to, provide this amazing mitigation. I've actually seen mitigation required that is ephemeral or really barely intermittent. They're functioning. It's still, in my experience, waters of the U.S., we're required mitigation, but the mitigation really only has to function at the function of that stream. So if the stream is functioning, but maybe not pristinely, that's what you're required to put back. Does that make sense?
Yes, I'm having trouble deciding if they would have to do a functional assessment on the stream because it isn't a stream, it's a sand bottom channel. Miss Lemon, you look like you have.
So I have kind of a sequencing in our program for dredge and fill. We're sequencing avoidance, like you should avoid, then you should minimize, and then the last resort is mitigation. So the functional assessment comes in at that last resort if there's no other way to avoid unavoidable impacts, right? It's for unavoidable impacts. So that's where that functional assessment would come into play, is after you avoid, after you minimize. And if there's no other option, you're taking away an aquatic resource and you have to mitigate that function or value. So again, in individual permits, that generally comes into play because they're more complex, which is why they're under a individual permit. With most of the general permit, or most of the activities for dredge and fill will fall under general permits, and there'll be eligibility and requirements in there and things that will tell you when you need to do certain things. But again, it's not going to be required for everything, probably for most things under general permits, but there is ability to look at avoidance and minimization and alternatives. Like, do we have to do it in this project area? Could we move over here and then there's no impact? So that's kind of what we're looking at, is of trying to avoid unavoidable impacts. And if there are unavoidable impacts, then you mitigate and conduct those functional assessments.
Thank you. This particular channel requires moving sediment every few years because there is such a large amount. Would they have to do a functional assessment every before they did the project let's say every 5 years?
Again, it depends on the activity. I mean, it could fall under a general permit. It could be what the Corps has done for some of those similar type of activities when it's a lot of sediment that's coming down, are letters of permission, which is kind of like an individual permit light. But then you're under the permit, you're meeting the requirements of the permit, and that's kind of what you operate under.
Okay. And do general permits have expiration dates?
They're typically issued for 5 years under the federal program. In our regulations, we do have the option of issuing permits for a longer term, up to 10 years, if it's appropriate and, you know, goes through the commission.
Okay. Yeah, I know some of those guys. Let me ask, I have a line of questions for Mr. Conley. My first one is the 500-hour requirement, 500 man hours required to develop a new permit. I look at the permits for many of the dischargers in New Mexico, and there's about 100 of them, as Miss Lemon said. And typically there's 3 or 4 pages of substance and 20 pages of boilerplate. Why does it take so much time? And these are not complicated, you know, they're little tiny sewage treatment. I'm sorry.
Yeah.
Wastewater reclamation facilities.
Sure. We'll have to walk through the permitting process a bit. But you start with reviewing an application. Obviously, there's often a site visit involved with that going out, ensuring that that information included in the application is appropriate and representative. Then you collect discharge data. Often that is available in, you know, the DMRs that are submitted to the state and EPA, but those are often summaries. They don't actually give you all the data. If you want to do a true characteristic of the effluent, you need to get the specific data from the discharger. So now you have to go work with the discharger to get all their individual data. There's often data points that you aren't entirely sure about. So you want to do data verification. Once you get your data together, then you go through your data handling process. And within the data handling process, this is, what if they take 2 samples on one day? How do you handle that? What if one is a non-detect, one's detectable but not quantifiable? You have to go through and standardize your data essentially and make it appropriate for use. And this is why if you have a lot of outfalls, it just takes so much more time. A lot of it is the data handling. So then you get your data straight. Then you begin your analysis, your reasonable potential analysis, where you're evaluating the impact on the receiving water itself. In many cases, before you do that, you have to understand certain characteristics of the receiving water to which they're discharging, which this means getting flow data, getting ambient pollutant concentrations if you potentially can. And then you have your effluent data, which is already characterized because you have that effluent data together, and you run your statistical analyses to determine if the downstream pollutant concentration after the discharge occurs is going to exceed the applicable water quality criteria. Oh, sorry. But before you even do that, I'm forgetting things, you have to identify the appropriate designated beneficial uses of the particular water body, which isn't very hard. That can be done in, you know, a few minutes. But select the appropriate criteria because based on those uses, your criteria is going to be different. So you get all your criteria together. And some of that criteria can be dependent on the characteristics of the receiving water. Metals are often hardness dependent. So now you need to know what hardness data you're going to utilize for determining the appropriate magnitude of applicable criteria. And identifying even the hardness that you're going to use, there's data handling, that steps that need to be done for that as well. You have to often reference guidance, and you guys are inland, so you don't have to look at salinity either. And if there's
there's someplace.
Oh, okay. If there's dilution, you have to evaluate dilution. That's probably not a big situation out here. This is all on top of any anti-DEG or anything like that too. So then you do your statistical analysis, determine what pollutants have the potential to cause an exceedance of applicable criteria within the receiving water. Once you identify what those pollutants are, and in many cases, I should say, some of that criteria is narrative. So it doesn't actually have a quantifiable value. So you have to interpret narrative in many cases and turn it into a quantifiable value. And then once you know what pollutants are likely to have reasonable potential to cause an exceedance, you calculate your effluent limits for each one of those. And that's just your water quality-based effluent limits. Now you got to go to your technology-based effluent limits. Technology-based effluent limits, it's going to depend if you have EPA promulgated effluent limitation guidelines or if your facility does not have applicable ELGs. If you do not have applicable ELGs, I'm going to be quite honest, the regs say that you are to calculate technology-based limits, which means you do an assessment of the industry in that particular facility, and determine to what extent they can treat their effluent and get the pollutant concentrations down. But water quality-based effluent limits are always more stringent than case by case. So there are very few states that actually go through that federal requirement, and EPA tends to not pursue, any action on that particular case. But in some cases you do. Some cases there's a treatment technology I need to be aware of, evaluate in this particular facility to see what they can meet. And there are statistics you can run on their effluent as well to see what they're technically capable of achieving. I'm doing this very high level. There are a number of other things too. If there are effluent limitation guidelines that are applicable, these are EPA promulgated technology-based effluent limits. You need to assess where they're applicable, because oftentimes these will have multiple subcategories that aren't applicable, and sometimes they're conflicting, and it takes time to evaluate which one is applicable. And then you have to determine the metrics on which those technology-based limits are applied. There's some kind of reasonable estimate of actual production that is going to be utilized, and you have to gather that data from the discharger. And they will have submitted that most likely within their application, but you need to verify it. Oftentimes data that's presented to you is presented to you in a very specific way on purpose, and so you want to get the pure raw data. So then you evaluate that to come up with a reasonable estimate of actual production and use that data to calculate your technology-based limit. Then you compare your water quality-based limits, your T-bells, you take the more stringent of the two. Technology-based limits, I'm sorry. I'm sorry. I'm trying to get through this. It's yeah. And I should say, if you have to do case by case, there are sometimes economic analyses that have to be performed as well. Once you have your technology-based limits, you compare those to your water quality-based effluent limits. Take the more stringent, because that discharge has to meet both of those criteria. It has to be protective of both water quality and representative of what is achievable based on the applicable technological standards and the technology that you identified. I definitely missed some steps here. Then you have your final effluent limits. Those need to be compared to your previous effluent limitations to make sure that you're meeting anti-backsliding regulations. And at this time, this is where you often go, oh, there's degradation, or I'm going to have to follow up and request anti-degradation, or hopefully you identified that earlier in the process. Once you have this, Once you know what your final effluent limits are, you've made sure that they're applicable with anti-backsliding regulations, because you're not allowed to have limits in your permit that are less stringent than the previous limits, except under certain situations, which happen all the time, and then you have to rationalize that. And then now you have your effluent limits. You have to establish your monitoring frequencies. Sometimes there's guidance for this, sometimes there's not, that you need to follow within the state. And then that's where you start applying not your standard conditions just go in the permit. Those are the boilerplate that you're talking about. But there are also special provisions that are typically required. And this can be highly dependent on the type of facility you're dealing with, but oftentimes, industrial stormwater discharges have stormwater pollution prevention plans. Other facilities have best management practice plans. MS4s have, what do they call them? Swamps, stormwater management plans. Yeah. So you have to assess the applicable. Yeah.
I don't think she caught the acronym.
Oh my gosh, I'm so sorry. I'm not. Okay.
I think my brain is.
You go through a lot of these steps. It's a very time-consuming process that looks very simple when it's all done, but there is nothing simple about it. Permit writers have to know engineering. They have to be good at statistics. They have to know biology, ecology, some hydrology. Have to be somewhat of an economist in order to write a permit. It is not an easy approach in most cases. Now, I say in most cases, when you have really small, very simple, something like a package plant, wastewater treatment plant, things change. You have a template for those. You can knock those out really quick, as long as there's not, one of the many things that can make that take a lot of time to. So it's a very long and detailed process, which the end result looks, the permit is hopefully very clean and short and concise. That's what good permit writers generate. But in addition to that permit, you're going to create a statement of basis or a fact sheet. So you might have a 20-page permit. You might have a 120-page fact sheet that supports that 20-page permit, because the public has a right to understand all of your rationale, all of the decision-making that went into it, where your water quality standards came from. If you had to determine the magnitude of criteria, what did you use, right? You're documenting everything within that fact sheet, including even your standard conditions and why they're being applied in your permit, even though they're in every permit. Why you establish the monitoring frequencies. So there's a lot that goes into it, and for her sake, I'm not going into it. I can continue to elaborate if you'd like me to. Oh, and I will say one of the biggest things, absolutely, is that it's a start-stop situation. You start for 4 hours, you hit a stopping point, you need information, it gets put down. And you might pick it up again the next day or the next day, and you lose efficiency, which is why, generally, we're contractors. We don't start permits till we have everything, so we can be more efficient than our state counterparts. States, they just dive in. And one of the things that we'll talk about in implementation is making sure that you have everything right from the beginning. So,
thank you. My question more relates to the small discharges, maybe less than 2 million gallons a day, to ephemeral streams, because that's where I think a lot of those, and these are all POTWs, we have very small industrial contributions to wastewater in this state, so you don't have to deal with technology-based effluent limit guidelines and things like that. And I assume that you've written several of those in Arizona.
So I have, I mentioned that I manage some permit development in Arizona. I haven't actually written the permits in Arizona, but I've written several small wastewater treatment plant.
Yeah. So that's for a new permit. How about for a renewal? Does that also take?
It's exactly the same. You don't take anything for granted as a permit writer. You don't just slap on a new set, a new cover sheet and move forward. You're going to, everything I just described happens every 5 years.
Except for maybe that anti-degradation. Except for maybe that anti-degradation analysis.
And in fact, having a permit renewal that's sometimes more difficult, because if you are going to remove monitoring, or again, you want to make a limit less stringent, now you have to deal with backsliding regulations and defend streamlining the permit essentially for the discharge.
Madam Hearing Officer, I have one more line of questions, and then I think we'll have to.
Yeah, in fact, if this is a good stopping point, that's fine.
No, this is a simple question.
Okay.
For him. So one of the things you've mentioned it a couple times during your testimony is that if we had more permits, the unit cost, the cost per permit would go down. And that is a real common phenomena with technology. If you're making 10 widgets, it's expensive. You make 1,000 widgets and they're less expensive. I don't see economies of scale in the permit process. It's still going to take 500 hours, regardless of whether you're doing one permit or 100 permits.
Mr. Commissioner, you are absolutely right in terms of how long it takes to write the permit. But for the program itself, there are fixed costs, like those administration costs. Those get spread out, and those are significant. Those get spread out over more permittees, right? So if you have guidance and you have 5 permittees that fall within the guidance, they essentially are bearing the cost of that one guide, the development of that guidance and the upkeep of that guidance. If you have 20, now you're getting some cost efficiency there. So there are fixed costs that can be diluted based on a larger permitting universe. And a lot of the program costs fall within that category. There are I would say comparatively, there are very few direct costs compared to the entire cost.
I don't remember your spreadsheets, but it didn't look to me like administration was that big a fraction of the $8.37 million.
Yeah, but I think the first line is 6,000 hours. The second one, I don't recall off the top of my head, it might be like 3,200 hours. But those are just 2 line items. There are other line items that get diluted as you gain some. You do gain some economy of scale, and once you have, you will get better permit writers that become. If you have 20 POTWs and you can just have 4 permit writers concentrate on POTWs, they're going to get much better at writing POTW permits and get much quicker. So they will gain some efficiency based on generating a particular type of.
Based on your experience, can you give me an estimate? Are we talking about a 5% reduction in cost, 10%?
So one of the challenges with the NPDES program, and you and I were just talking about this a little bit, is retaining employees, because as a permit writer, oftentimes those are engineers that have options for employment. They're at a state that very often does not pay them competitively for what their skill sets are worth. Industry hates them because they're making industry incur costs. Environmental groups generally don't like them. When I say don't like them, I mean they're just talking. You know, they submit negative comments that make you feel really bad when you poured your heart into something. It's a thankless job. So the industry doesn't like you. Environmental groups don't like you. Politicians don't like you because you're not fast enough. You're not turning things out. You're upsetting you're upsetting industry. It is. And the management is just saying, we have a backlog, let's move faster. So it is a thankless job. There is a high turnover rate, which is unfortunate because it takes about 3 years until you have a okay permit writer. I would say it takes 5 years until you have a good permit writer, and it probably takes 10 to 12 years until you've got somebody who's completely independent who can handle the challenges amongst a wide variety of facilities and permit.
Thank you very much. And thank you to the panel as well. I appreciate it.
Thank you.
We'll talk tomorrow.
All right. Thank you so much. We'll be in this room again at 9 o'clock tomorrow morning. Good night.